So Saul Goodman found us an interesting one again. Not that Saul Goodman. So, I don't remember his name. Fred has a big jacked up truck. Well, it might not be jacked up, but it's a big diesel truck. And he totally could have worked on it himself, but he's got too much going on. So he took it to the mechanic, Bob. So Bob gets to fixing it, and there's more wrong with it than there should have been. So he fixes everything. And Fred doesn't think it should have cost as much as Bob charged him for it. And instead of, working it out and talking like normal adults, Fred just goes and takes the truck. So Bob comes in and is like, okay, well, he just took the truck and didn't pay me for it. So he calls the cops. Now we're in court. Fred says he didn't authorize that additional work and he didn't want those Napa batteries. But Bob says couldn't have got the truck off the lot without it, couldn't do the work without it, couldn't even get it in the garage without it because it wouldn't start. Oh, it's a weird one. I love Kansas.
Good morning. Do we have everyone here that we expect to have?
I think we've got everybody. Yeah, looks like it's wrong.
Right.
Yeah, everybody here. Mr. Hunter's with me, and this is him right here. He may blur in and out sometimes depending on how close to the screen he is.
Okay. Well, let's go on the record then, Missy. We are on the record in the 13th Judicial District, the District Court of Greenwood County, Kansas. Case number 2023 LM81, Cliffs Gas and Diesel Repair Service versus Scott Hunter. Please announce appearances.
Your Honor, the plaintiff appears via Zoom with counsel Pauline.
Your Honor, may it please the court, William McClendon appears for the respondent with Scott Hunter.
We were last here in this case. Oh, my notes aren't in my file. We were last here.
Your Honor, actually, this was a case, if I don't mind, I think I could get the court caught up. We actually have not conducted a formal hearing in this matter. We did have an answer date set. Unfortunately, this is one of those cases that was filed, I believe, just immediately prior to the whole Odyssey system going offline. And it was a little difficult to figure out who had been served. By the time we came to that answer date, there weren't any appearances by the defendant on that date. I'd inquired, but I also couldn't see the returns of service because of everything being down. I'd inquired of the sheriff because it had gone out of county for service, and there was quite honestly some miscommunication between himself and I. I thought when he indicated it had gone out for service and had been returned, but that implied that it had been served. But I have confirmed with Sheriff Walker that their dispatch has searched and that, yes, that in fact it was not served. It was returned unserved, which is why Mr. McClendon filed his motion. So at this point in time, Your Honor, we consent to the motion. We acknowledge that that's the appropriate thing to do because the return was unserved. So we have no objection to the court granting that motion. And at this point in time, I'd be requesting that we treat this as a status conference and establish some deadlines and dates moving forward. I'll let Mr. McClendon add in anything he'd like to, or I'll turn it over to him. Not like I get to permit him to do something here. Good grief.
Well, we had a default judgment believing that service had been granted, and then now we have this motion to set aside that default judgment filed by Mr. McClendon on the grounds that there was no legal service. Basically, Mr. McClendon, that's your position?
Yes, it is, Your Honor.
All right. Well, I will grant the motion to set aside the default judgment, which will take us back to the original petition filed back September. And then, Mr. McClendon, have you and your client received a copy of that petition now?
I do have a copy of it. I will need some time to get an answer on file, though.
All right. The petition alleges that your client, Mr. McClendon, owes $7,876.41. And you'd like some time to file a response. How much time would you like?
Oh, would 21 days be appropriate?
I was thinking 30 days. Mr. Dean, do you have a thought?
It's a pretty short answer to file. I would say 21 is good, Your Honor.
Okay, Missy, do you have something in 21 days?
Well, Your Honor, actually, what I'd ask is that if it's acceptable to court, Mr. McClendon, that we just have a date for the answer to be filed. I would like to have and just go ahead and set a pretrial date and a trial date, and hopefully in between that, maybe the parties can come to an agreement. And if not, we've kind of got everything mapped out. And a witness and exhibit list, which I think is already required by statute, giving us a limited action for that information to be exchanged. But if we just go ahead and get some agreeable dates, I think that'd be my recommendation as to how to proceed.
Mr. McClendon, is that agreeable to you, that proposed
It
procedure?
is. If we go that route, can we do 30 just for the for the sake of time and compiling all that?
All right, Missy, what for pretrial around 30 days?
As he just mentioned, this case was filed right before the court's online system was hacked and crashed. It took him like 6 to 8 months, maybe even longer, to get it back online. The Court of Appeals still isn't online, I don't think. This is the system for the entire state of Kansas, like Supreme Court all the way down. One of the problems they encountered was the inability to confirm service. When the claim was filed and the respondent didn't file an answer in the prescribed time frame, a default judgment was entered because that's standard procedure. Obviously, he wasn't happy with this, and so he got an attorney to set it aside to take it to court because he never actually knew about it. They were able to confirm that he was never actually served, so they have to set it back so that he has a chance to actually answer because it was their fault. The taking down of the online system caused so much damage and so much hardship for the people involved. It really makes you wonder why someone would do something like that. So after this point, the hearing went on for 20 additional minutes, all scheduling talk. Nobody could agree on a date and nobody was available on the same date. So we're going to jump ahead to the May trial date.
Morning. We are on the record in the 13th Judicial District, the District Court of Greenwood, County, Kansas. Cliffs GDR Inc. versus Scott Hunter. Please announce appearances.
Your Honor, Cliff GDR Inc. Appears through its principal, Cliff Strickler, with counsel Paul Eding, all by Zoom.
Okay.
Willie McClendon for the defendant in this matter, Scott Hunter, who appears with counsel.
Very well, thank you. Now, we had a pre-trial a while back and gave opportunity to try to see if there was any resolution short of trial. Were we successful on that, Mr. Dean?
Unfortunately, no, Your Honor. This is just, sometimes you just have a case that has to be submitted to the court for a decision. Fortunately, I think it will be fairly quick presentation. It's not an overly complicated fact scenario.
All right, and Missy, did I leave some papers out there relevant to this, maybe?
No, is it in that stack that I put on your desk a little bit ago?
Thank you. It is. All right. So are there, and Mr. McClendon, you're in agreement with those comments?
Yes, Your Honor.
All right. Are there any opening statements?
Your Honor, I'd waive opening statements. I don't know that the court really needs them for basically an auto repair dispute.
Okay. Mr.
I'll
McClendon,
waive as well. Your Honor.
Very well, Mr. Dean, you may call your first witness.
Your Honor, I'd call Scott Hunter.
And where is Mr. Hunter? I am not seeing.
He's off to Mr. McClendon's side.
Oh, he's Mr.
Your Honor,
McClendon.
my client is actually sitting next to me, but
There we
the way
go.
we're kind of configured here, it's easier. When he testifies, I'll turn the screen to him and you won't see me, so.
Very well. So, Mr.
Um,
Hunter, are you ready, Mr. Dean?
yes,
Okay, please raise your right hand, sir. Mr. Hunter, do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. Please proceed, Mr. Dean.
Your Honor, excuse me, Your Honor. Mr. Hunter, would you please state your full name for the record?
Scott Hunter.
And Mr. Hunter, can you tell me how it is that you came to take your vehicle to Cliff's GDR Inc. for repair?
Yeah, several people that we come in contact said he worked on diesel pickups, diesel engines. And there's not that many of them close in the country. So we went and spoke to him about working on this one.
Okay. And so do you recall when it is you first made contact with Mr. Strickler?
I think back in May of 2023.
And what issues were you having with your vehicle at that time?
It was missing out on one cylinder.
And so based upon that, you took your vehicle to Mr. Strickler, asked if he could repair it.
Yes.
Yeah. What other discussions, if any, did you have with Mr. Strickler about the work that needed to be done on the vehicle?
That I needed to have this mess identified, and we need to fix the mess. I wanted to keep the amount we spent down on that one because we were getting ready to sell it. It was a high mileage pickup, and we were going to get ready and sell it. So I didn't want to completely redo the engine. I just wanted the mess taken care of.
Are you a mechanic?
By trade, no.
Do you do diesel
Do I
engine?
work engines? Yes. I've
You do-
repaired my own since I was in high school.
Do you repair this type of engine?
Diesels? Yes.
You just didn't want to do the work on this one?
I didn't have the time, and not only that, nowadays too many of the wrenches and tools are metric. I don't have the metric sets that it takes to work on some of this newer stuff, and it's easier for me to hire someone that does do it to do this. And not only that, we've been in a drought, so I was running 7 days a week on a bulldozer. I didn't have time to work on things.
All right, very good. And so you take it in, you talk to Cliff about getting it fixed, and you told him you wanted to keep costs down. And anything else?
Not that I know of.
Did you tell him you were getting ready to sell it?
Yes.
It's easier to sell a vehicle that runs properly, correct?
Well, it needs to hit on all the cylinders, yes.
And so after you left so did you leave your vehicle there that day that you took it in?
Yes. And the day I left it, he said that he had given me a day to bring it up on. And the day that I took it in and left it, he said that he was running behind and was going to be a little longer before he could work on it. I said, that is fine. That's not a problem.
Okay. And
It's
you know
not a
when that
pickup.
was?
It's not a unit that I was working every day. Sorry, sir.
No, you're fine. My apologies for cutting in before you were finished. Do you recall what day that was when you took it in?
It was back in May. That's all I can tell you now.
And just for clarity's sake, you said you had this conversation. So the conversation you had about the repair work to be done on the vehicle was on a different day than the day you brought the vehicle in?
No.
Okay.
No.
So that was all in one day.
Yeah. I spoke with Cliff and told him what we needed done, because I knew he had a yard full of vehicles there. And he told me then what day to bring it up.
I see.
And when I took it up, yeah, we talked about what I wanted to do to it when he agreed to work on it. And when I delivered the pickup on that day, he told me it's when he said he was running way behind, and he was. He had a lot of stuff there.
And what is it that Mr. Strickler told you that day when you advised him about this repair work that you wanted done?
He agreed to do it, I guess. I mean, I don't know what
I'm just
else.
asking if you, I mean,
Yeah,
you were
well, I'm
there.
trying to think what else there might be. We discussed the vehicle, and he said straight away that, well, he's quite sure it was an injector, and that I also, I mean, I agreed with. Uh, there was nothing about any in-depth work that was going to be done on it.
There was no in-depth conversation about work to be done other than it appeared there was an injector issue.
No, just the injector issue and the fact that I didn't want to spend a lot of money on it because we were going to get rid of it. It was high mileage, and I didn't want to have more in a repair bill than what you get out of it.
You'd agree with me, sir. Not wanting to spend a lot of money on a diesel engine repair is somewhat of a subjective view, correct?
It's what?
Subjective.
We discussed the amount of money, what said $1,500 or so that would get us up and going.
That's your claim, correct?
Yes, that's my claim.
So when what was your anticipation after you left the vehicle and had this discussion with him?
My anticipation was when he got time to get it in, he would get it fixed. He would put an injector in it, and it would run when we were done.
All right. So you weren't expecting any other contact other than to say, hey, your vehicle's done and ready to go.
Yes, I was. I was expecting him after he diagnosed the problem to let me know what it looked like we were going to spend.
It's a little bit different than what you just said, but fair enough. So when is it that you finally heard back from Mr. Strickler that the vehicle is ready to go?
He sent a letter out with, it wasn't a bill, it was an estimate. But the first thing I knew for sure was on the 19th day of July. And he had sent a text a couple days before. I could not read it. And I said, send me a hard copy because we definitely have a discrepancy here. Because I could see he was wanting to spend a lot of money on it.
I'm sorry, you were breaking up a little bit there. Did you say he sent you a text with what you thought was an estimate?
Yes. The reason I thought it was is because it said on it, it was an estimate.
Okay. And do you recall Mr. Do you call Mr. Strickler trying to call you on multiple occasions and leaving you messages?
He sent that text and he did call one time and said he was going to be out of the shop for a week. He'd had a new grandchild, family member, something, and he was going to be gone.
Okay, sir, do you have plaintiff's exhibit number 2 close by? Did you get these in? You got those emails, right, Mr. McClendon? All right, so I'm showing you what I've marked as plaintiff's exhibit number 2. I guess if you don't have them there with you, I'm just going to hold.
Excuse me, Mr. Dean, did you by chance send those to Missy or file those in the file?
Yeah, we Judge, we emailed them to you. We emailed them to Mr. McClendon. I was under the anticipation that everybody would simply print their exhibits so everybody had them in hand. But if that's not
Well,
the case, I'll do it
If
simple.
Missy or I have them, she might be able to just screenshot those for you. Missy, do you have those or did he send them direct to me?
I do have them.
You do have them?
Yes.
All right, so Mr. Dean, you're wanting to present plaintiff's exhibit 2?
Well, I thought it would be helpful for him to have it in hand. I wasn't intending on introducing it through him.
Okay, well, it's whatever you want to do. I certainly don't want to interfere with your presentation.
No, I'll just go through it in this fashion. Mr. Hunter, would you agree that on May 17th at 10:35 that Mr. Hunter, that Mr. Strickler tried to call you and left you a message?
My phone doesn't show that I ever got that. Now, there is one thing, Mr.
Do
Dean.
you have your phone with you?
Right here. There is one thing that I would say, and that is when we're cleaning ponds, building ponds, if we're in an area where service is poor anyway, which out in the hills in this country, you do have that from time to time. If we're down in the bottom of that pond coming out, we won't register a call. Not
So
even
it
from
won't
my
ever
wife,
even-
and that really is something to worry about.
It won't ever show up even once you get back into an area where you have service that you missed a call.
Not if it didn't ring. Not if it wasn't something that would cause the phone to ring.
What-
No, it won't.
Out of curiosity, sir, what type of phone do you have?
It's a Motorola. And it's
And
my
where's your
service. is through
Verizon service. Very good. Now on would you agree that Mr. Strickler tried to call you on May 23rd at 8:20 a.m.?
I always thought Kansas was flat and that there were that's why there's so many tornadoes there, right? That's why Dorothy got her wild ride. That's not true. Kansas' highest mountain is Mount Sunflower, whose peak is 4,039 feet above sea level. But the lowest point is 679 feet above sea level. At the Verdigris River, Kansas is a prairie state whose elevation rises gradually from the Mississippi River Valley in the east to the high plains in the west. The fertile plains of eastern Kansas are quite hilly. Hilly is a cool word. It's hilly. I live in a hilly place. No, I don't. I live in a flat place below sea level that won't even exist in a couple of years.
Missy, if you're able to print those out, you can bring those in if you have time.
Sorry, Your Honor, my intent was to send them to the county attorney's office, have them print them and hand them to you. So you had a hard copy already, but fortunately, some of the hearings I had decided they wanted more of my time yesterday than what I
Yes,
thought.
we had that problem. Missy and
Much
I-
like this morning, 5-minute hearing, but it took 55 minutes to get it called to be heard. Mr. Strickler, did you have a chance to look there? May 23rd, 2023.
Your phone records.
Okay, what?
Go back to May. If they'll go that far. Yep. Oh, that's. Sorry. There we go.
Mr. McClendon, is he going through his
It,
phone calls?
off. Yes, Your Honor, it cuts off. So we have nothing.
I'm sorry, Mr. McClendon, I'm not hearing you.
His phone records on his personal device cut off after April. And so we have
I'm
nothing
still
past
not
that.
hearing you. I think you're trying to share microphones. It's not picking you up. Okay.
His phone records right here and nothing goes. Can you not hear me?
No, you're chopping in and up, in and out and,
There it seemed to get a little better.
okay.
Can you hear me now,
Yes, that's great.
baby?
Go ahead.
So looking at his phone records, there's nothing past April of this year.
Okay.
So, Mr. Hunter, let me ask it to you in this fashion. Do you recall having a phone call from Mr. Strickler in May where he informed you that the injectors were bad and recommended replacing?
Mr. Strickler called me and informed me that the number one injector was hung open and it needed replaced. And he said also that number 5, he thought maybe was a little weak. And that was it.
Did he talk to you about the pass-through harness as well at that time?
No,
And do you recall receiving a phone call from him on June 13th of 2023?
unless that's the call that he made saying he was going to be out of the office, something about family matter, had a new grandchild or something. Because I don't know what it is. I can't tell you when that many calls come. In summertime, there's a lot of calls come in every day.
When's the next time you were able to talk to him? Maybe it's an easier way to ask this. When's the next time you actually remember being able to speak with Mr. Strickler on the phone? After you left the vehicle there and he said he would get to it as soon as he could. But it was going to be a while because he was backed up.
I'm assuming that would be in June, and that was in person.
Okay, June, and it was in person. So you were at his shop?
I spoke to him a minute about how he's getting along with it. At the same time, I was getting fuel. At that time, I got fuel from East Side every day.
Okay. My apologies. I don't know when you get fuel or what you do on a daily basis. So at that point in time, though, the vehicle wasn't done, correct?
Yes.
So when's the next time you spoke to him? What was that conversation about?
The next time that I spoke with him is when he said it was done, and he texted me a copy of an estimate, and it says it is just an estimate. He did tell me that, and I said, well, send a hard copy or something because I cannot read it, and I sure can't print it or enlarge it where I can read it.
All right. So on June, do you show a text from him on June 13th saying that your truck is done?
On what date, sir?
June 13th, 2023.
Well, I don't have, but I don't have anything in the 13th.
Yes, Paul. June 13th.
Yeah, well, I thought you were talking about a phone call. Yeah, I've got a text on June 13th that says your truck is done. And yes, we did speak after that because that is when I told him first that he needed to send me a hard copy so I could read it. And then on 7/18, I hadn't got anything, so I sent him another text.
Hold on. He sent you a picture of a bill. You're calling it an estimate on July 7th, correct?
Yes, sir. It says it's an estimate, sir.
And that's July 7th?
Yes.
Okay.
And then on July, now you would agree with me at this point in time, you knew since June 13th your truck was done.
No, I knew that he had sent an estimate out for what he needed or wanted to spend on it.
All right, let's just back up then again. Right above that text on June 13th, did you not just say you received a text saying your truck was done?
Yes, I did.
And then almost a month later, on July 7th, you received a text that you're saying was an estimate for the work to be done on the truck that had already been completed, correct?
We had a phone call with there, and when I told him to send down this information,
I'm not.
And what he sent was an estimate.
Great on the phone call, but you had a text on July 7th as well that was an estimate. as you say, that you couldn't read, correct?
Yes, and it wasn't the full page, sir. It was only part of a page.
And then you waited until July 18th to respond back, said reply could not read in regards to the picture of the bill or the estimate, excuse me.
I would have spoken with him at his place of business, send a hard bill. A hard bill in writing, send it to my address.
I'm going to ask this question again. I didn't ask you about a phone call at this point in time. I asked you, replied 11 days later to the text of the estimate on July 18th, telling Mr. Strickler that you couldn't read it.
Yes. Yes, that's in writing. That's provable.
And then then what do you show as your next text with Mr. Strickler?
I'm sorry, gentlemen. So June 13th was the text,
Truck is done.
the truck is done, and then was there a text July 7?
July 7th was a picture of what we refer to as a bill and Mr. Hunter refers to as an estimate.
Was that the day he said he said send me a hard copy, or was July 18th, or was that message on both days?
On July 18th, I believe he just agreed that he sent a text saying could not read.
Okay. And that was the first time he sent that particular text. Is that the test?
That's correct.
Okay, thank you. I'm sorry.
And Your Honor, maybe it'll just be
I just wanted to make sure I had this right, because I thought I heard him say he sent that on the July 7th, and then I heard July 18th. So I just needed to clarify what he said.
Your Honor, I could actually send screenshots.
That's
Sir,
okay.
I take it
Sir,
I take it you have your phone right there in front of you. Would you agree your phone's going to show on June 13th your truck's done?
Yes.
And then on July 7th, an actual photo of the bill that you say estimate.
Would you agree that it says right on it, sir, that this is an estimate?
Yeah, there's terminology that says estimate on it.
Would you further agree with me that that's only half a page
oh,
that's
wait
showing?
a minute. Wait a minute. This is Mr. Dean's questioning, sir. You and your attorney will have a chance to present your case. Go ahead, Mr. Dean.
Thank you, Your Honor. I was kind of enjoying some of the questions. So would you agree with me at the bottom it says balance due?
Yes, it does.
Yeah. All right, thank you. And then would you agree after that you did send 11 days later a text saying can't read it. Please send me a hard copy. And then Mr. Strickler replied right back to you and said, where would you like the invoice sent? And then you replied back the next day to that address, correct?
Yep.
And that would have been on July 19th. That was the last text message you had.
The last one I have showing on my phone.
So when did you receive the hard copy of the bill?
It shows on the 19th day of July. It was postmarked in Wichita. We received it. For some reason, the mail was up and running pretty good. We received it on the 21st.
Okay. So I'm going to show you what's been marked as plaintiff's exhibit number 1.
And I do have the hard copy of that now. Missy printed that and gave it to me.
And sir, this does that look like an accurate reflection of the bill that you received? Or the estimate that you received, as you like to call it?
move it over a little bit where I can see the full
Again,
thing.
Missy can screenshot that if you want, council.
Is this the one?
She can put it on the screen if that.
I think
would-
he's got a copy of it there in
Okay.
front of him.
I've got it mirrored here, with
All
you
right,
guys.
I have a copy too, so go ahead, please.
All right, so it says Cliffs Gas, the diesel repair at the top, and at the very bottom, it has a balance due $7,876.41.
Okay, that's not an exact copy of what I received.
What's the bill that show due on yours? Because this is actually August 10th, an additional bill printout. Yours, you said was July 19th?
Yep.
And what's the July 19th bill so that was due?
$6,562.20.
$6,572.26.
65, 62, 20.
Gotcha. Okay, and on your bill, did it show fuel injector, fuel injector actual FMG OEM new unit price $693.74 on the top line
Yes, it does.
for a total of $4,162.44.
It shows that, yes.
And the next item, valve cover gasket set $92.02.
Yes,
And the next set, injection pass-through harness, $194.65
yes,
for a total of $583.95 on that part.
yes, it is.
Battery, Napa Legend Professional, $192.08
Yes, it does.
for a total of $384.16. Correct?
Yes,
And then basically a core is the next one, $18 on each for a total of $36.
yes,
And then a credit for that as well. Correct?
yes,
A new starter, $279.30.
yes,
Starter assembly, remove and replace for $142.50.
yes,
Oh, but I skipped over a line up top, the third entry down on the far right hand column, fuel injector, remove and replace $332.50.
yes.
And then what does your bill have a storage fee
No,
indicated on it? No
no, it
storage
does
fee, correct?
not.
Does your bill have any type of a late fee or probably what's actually just an interest calculation on it?
No, this bill that we're reading off of from 7/7 of 23 does not have that.
Okay. So it's got labor in the amount of $1,675.20, correct? Total? Go right down.
No, my bill does not have that.
What's your bill have then?
If you pull that screenshot up again, we can look at it together, sir.
I don't have the screenshot.
Missy,
Oh,
would it take you more than a minute to put that up?
Oh, actually,
Which exhibit is it?
Plaintiff's Exhibit 1.
sorry. Labor 475, parts 5,497.87. Correct?
that is what my bill shows, Mr. Dean, yes.
And Eureka sales tax 9.5% for 569.33.
Yes,
Total 6,562.20.
Mr. Dean, I am not That's not adding up with Exhibit 1. Are you reading from a different exhibit?
I'm reading from the one he has in his possession, Your Honor. And I
All
think
right.
the difference is
So Missy,
there- the storage, Your Honor, that was added in later, but we'll deal with that when we go to Exhibit 1 through my client.
so are we on Exhibit 1 or a different exhibit? Did we switch?
I'm referencing, so this is the testimony that he's giving regarding and actually, I am going to,
He said he received a bill on 7/19, the hard copy. Is that what you're referencing?
correct. This is the bill he received in July
Okay,
after Mr. Hunter asked Mr. Strickler to send him a hard copy because he couldn't read it from the text.
okay.
I will go ahead and have this. I'm forwarding this particular one to myself. And Mr. Strickler's phone. I don't know if, unless they want to, they've got that marked as a defense exhibit. We could always use that, but I'll go ahead and get that exhibit printed as well, Your Honor, and mark it, since that's what's been referenced as it was too small. All right. So Mr. Strickler, excuse me, Mr. Hunter. So you were notified July 13th that the truck was done. And apparently you didn't have any contact with him until he sent you a picture of the bill on July 7th.
I had contact with him in which I told him to send me a hard copy because there are discrepancies.
We went over that. That occurred on July 18th. So you have a record indicating sometime between June 13th and July 7th that you had some kind of contact with Mr. Strickler?
It was about the bill, sending a hard copy.
On what date?
I'm not going to try to tell you exactly what it was because it was an in-person thing. I said, send me a bill out.
Okay. Sounds good. Now, Mr. Hunter, after that, would you agree with me that Mr. Strickler tried to contact you multiple times by phone regarding taking care of this bill?
No, he did not. I got the hard copy of the bill, and then I was able to see the rest of it. And I still do not call it a bill. I have not received a bill to this day, with the exception of the amount of money that you're trying to sue me for, because it says very plainly that it's estimate number 3518.
And it says very plainly that there's a balance due on it, does it not?
Yes, it does.
So despite Mr. Strickler sending you this bill clear back in early July, and then sending you a hard copy again in July, and haven't told you since June 13th that your truck was done, you don't believe, so you said he didn't ever try to contact you again by phone to try to get this taken care of, correct?
No, I'm saying I didn't receive any type of message or call. No, I'm not going to say anything about someone else and make it out to be that I'm being illegal with them or I'm being improper. I'm saying that I did not receive it.
Just out of
I'm
curiosity,
saying that I have returned calls that I received notification of.
just out of curiosity, were you able to receive a call from anybody in the month of July of 2023?
Yes.
And in early August of 2023, did you get phone calls from other people then as well?
I'm quite sure I did.
Okay, so what's the next contact you had with Mr. Strickler in person?
In person?
Yeah.
I haven't had one since the day that we've already spoken of, just before I got the hard copy of the bill And it said right on it that I needed to get the vehicle out, and I did.
Now, where is that you see the language that you need to get the vehicle out?
All vehicles left over 48 hours after repairs are completed will incur a $10 per day storage fee.
Okay, that's not a directive for you to get the vehicle out. This is telling you how much it costs to have it there, correct?
It does for fact.
And so you got your check ready and you went up to go get the vehicle and pay for it, correct? When you removed it?
Nope, I sure didn't.
In fact, you took a second set of keys to the vehicle, didn't contact Mr. Strickler, went in when he wasn't around and removed the vehicle, correct?
He was not at his shop that day. We did get in the pickup and get it out of there.
With a second set of keys.
Yes, I have a second set of keys to it.
Right. So the original keys that you took on with the vehicle is still in Mr. Strickler's shop, correct? To your knowledge.
Repeat that, please.
The set of keys that you took with the vehicle to when you brought it in for repair is still with Mr. Strickler.
I'm assuming he's still got a set of keys that I'd like to have back.
And then you didn't make an offer to pay anything until after law enforcement had contacted you about removing that vehicle that had a mechanic's lien upon it, correct?
No, that's not correct.
Why
I had
would
a
you do?
call from Cliff Strickler Monday morning. He was threatening in his call and told me that needed paid before it was moved. And yet it says on his invoice that if it's not taken care of within 30 days, he's going to add to it. Standard operating procedure oftentimes is not that you pay the bill before it goes out the door, or else you leave everything set and have a fight in the driveway. He knew that I had not ordered all this much work, and it was time to start working it out. Very shortly after that is when I was contacted by law enforcement, and everything transpired from there.
And when is it that you cut a check to Mr. Strickler for the work done?
Whatever day it was that Officer Cordell spoke with me, he asked me if I thought I owed anything. I explained to him what it was and why. And I said, I'll gladly pay for the work that I've ordered done.
So
And did.
After you took the vehicle, you were contacted by law enforcement, and then you told them you were going to pay what you thought you should on the truck, and that was what occurred, correct?
For the work that I had ordered to be done on the truck, yes.
Okay. And that check was not accepted by Mr. Strickler, correct?
I'm assuming not. It's never been presented for payment.
All right, Your Honor, I don't believe I have any further questions for Mr. Hunter at this time.
Very well, Mr. McClendon, cross-examination.
Mr. Hunter, did you have any agreed upon price? Did he provide you with any estimates at the original date in May as to how much it would cost?
No. We had a discussion that it wasn't to go over $1,500 because that is plenty of money to put an injector in a truck and his labor diagnosis.
Did you at any time ever tell him that you wanted to replace all the injectors?
No.
And were you clear? What did you tell him exactly when he called you saying injector 1 and 5 were missing?
I told him at number one, sure needed replaced. And I said if he thought it was that big an issue to replace number 5, I guess we would, because he told me that they would be in the neighborhood $400 per injector.
Where did you get the $400 from?
That was the figure that he quoted me on the phone.
So he quoted you $400 per injector on the phone.
Yes. And my thought was he's gonna put one and possibly two.
And you talked about no other work about needing a starter or new batteries or any other type of harnesses, correct?
No, the starter and the batteries were fine. The day we started up, packed it off, unloaded the frame. No, it didn't need that.
So the vehicle was still in a running order when you dropped it off with him, correct?
Yes, it
It
was.
was just runner up.
Yes.
No further questions, Your Honor, at this time.
All right, any redirect, Mr. Dean?
Yes. Yes, Your Honor, just briefly. Mr. Hunter, so your starter wasn't dragging at all at any point in time, wasn't missing at all before
No,
you
it was
took the vehicle in? Huh?
No, it was just fine.
Started to work perfect. Okay, very good. I don't even have further questions for this witness, Your Honor.
All right, you may call your next
Should we tell him
witness.
that the starter was under warranty?
I'll get that.
Yes, Your Honor. At this point in time, I would call Mr. Strickler.
Very well. Mr. Strickler, please raise your right hand. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, ma'am.
Thank you. Please proceed, Mr. Dean.
Thank you, Your Honor. My apologies, Your Honor. I need to step over here and grab this exhibit that I just sent to the printer so that we can have those for clarity, and I'll have my assistant forward it to you as well, and
Send it to
Mr. McClendon. Sorry. Give me just one.
You just send that to Missy, that'd be good.
Your Honor, that's been marked as plaintiff's exhibit 12 and it's been sent out to everybody. Mr. Strickler, Your Honor, at this point in time, I'm again call Mr. Strickler. Can't remember whether you swore him in yet or not.
I did. You're still under oath, Mr. Strickler?
Yes, ma'am.
Mr. Strickler, for the record, you are the owner of Cliff's Gas and Diesel, or Cliff's GDR Inc., correct?
Yes, I am.
And how long have you been a mechanic?
Little over 16 years. Went into business for myself on July 1st of 2018 and opened Cliff's GDR Inc.
So you've been at that same location since 2018?
Yes.
I'm just going to go through this chronologically, but no, to make it easier, we'll just go through exhibit number 1. Did you look at that and tell me what that is?
That is the actual bill. The way I'm a Napa Auto Care Center, so they have my whole computer set up. So the only way that I can do billing is through this as an estimate, and I can't invoice it and send out invoices until it's actually paid. If I authorize it as an invoice, it's saying that it's already paid, and then I have to pay the taxes on that afterwards. There are instances where I do have to carry people, or I don't have to, but I choose to carry people on bills, so I don't invoice them until they're paid in full. That way I don't pay the taxes. I've carried stuff up to 2 or 3 months. That way I'm not paying taxes on something I haven't been paid for yet.
So when you say you're a Napa Auto Care Center repair center, is that some type of agreement that you've entered into with Napa?
Yes, it is.
And as part of that agreement, what is it that Napa provides to you?
So I get discounted prices on parts. They set up my computer system to where I'm directly attached to their computer system to where I can order parts directly from them. They also have my Mitchell account, which goes through them, which gives the estimates on the labor and everything else. Anything that has to do with computer and billing and parts ordering goes through Napa.
So who sets the price on this that we're going to refer to as an estimate, but is actually a bill? Who sets the price for those items on that document?
Napa has a matrix that all the bills, I pull the bill, or I pull the part directly from them and add it to the estimate. When it adds it to the estimate, it automatically ups the price to what I'm supposed to charge for that for that part. That is my profit margin from my actual cost to the build cost.
So that's basic, but that's all established by Napa. In other words, they're marketing their parts at the prices that they are wanting, but that they're establishing.
Yes.
Much, I guess, kind of a similar analysis would be a car manufacturer. They set their price at the end of the day, and they've got their markups on their various components of the vehicle that they manufacture. Correct?
Yes.
But Napa sets the price on their parts, and GM sets the price on their vehicles. Correct?
Yes.
In regards to labor, is that something that you establish, or you agree to basically work at what Napa says you should be charging for that work?
So the labor itself comes through a Mitchell account, which is also tied to my Napa Auto Care Center. So when I go in and I type in that we're replacing the injectors, it automatically brings up the number, and then I click on it and it automatically moves it to the estimate as well. So Napa sets, and whether if it calls for 3 hours and it takes me 6, I get paid for 3. If it calls for 3 hours and it takes me 1, I get paid. I'm supposed to get paid for the 3, but I don't operate that way. I generally mark that labor down. I just don't feel right overcharging somebody that I didn't put in that many hours on.
But you don't ever round up if you go over.
No, I do not. That's just that the shop loses at that point.
So in plaintiff's exhibit number 1, is that a bill that you generated in August of 2023? Is basically a follow-up invoice to Mr. Hunter?
Yes, it is.
And you sent that to him?
This bill I did not send to him. This is the bill after he had already come and got the truck. I sent the bill that I sent him, the hard copy. I sent to him, and I highlighted the $10 a day storage and the 12,000 mile and the 10% late fee. At that point, I wasn't going to charge that. I try not to charge that. But then when he came and got the truck on 8/5 of 23, I didn't realize it until 8/7 of 23 that the truck was gone. And then I called and left a message saying that that's not the way I do business, that everything has to be paid for or some agreement has to be made before the vehicle is removed from my lot.
And Mr. Hunter, all of this notification.
I had not added the storage, and I had not added the late fee until the vehicle was removed from my lot without being paid, with no intention of paying.
So that's the difference between the billing that Mr. Hunter was speaking of that he'd received via text.
Yes, it is.
And then you sent him that bill that also, while this photo may not be perfect of it, would have had this information about the late fee, or basically it looks like an interest rate.
Yes.
Plus the $10 per day.
Yes, the hard copy would have that, and it was highlighted on the copy that I sent him.
And I believe he indicated he received that on July 19th.
21st, I believe. It was marked in Wichita on the 19th.
And Your Honor, you probably should have a copy of it. This is the screenshot.
I do have that, exhibit 12. And
So, yes. Your Honor, at this time, I'd move to amend plaintiff's exhibit 1.
any objection to plaintiff's exhibit 1 being admitted? Mr. McClendon, I'm sorry, you're still muted.
It said no. I could read his lips on that one.
No, Your Honor.
No objection, okay.
And Mr. Hunter, Mr. Strickler, does that appear to be the copy of the screenshot that was taken from your phone and the text exchange between you and Mr. Hunter?
Yes, it is.
And I think everybody should have a copy of this by now. Move to admit plaintiff's exhibit 12.
Mr. McClendon, if you'd unmute, and any objection?
No objection, Your Honor.
There being no objection, plaintiff 12 will be admitted, as well as previously admitted plaintiff's exhibit 1.
So while plaintiff's exhibit number 12, Mr. Hunter has information cut off at the top and bottom because it's a photo. That's an accurate picture of the billing that was sent to him. The hard copy of that bill was then sent to him as he requested, correct?
Yes, it was.
And that would have had the information regarding interest and storage, etc., as indicated on the bottom of Plaintiff's Exhibit 1, because it was a full copy.
Yes.
Now, did you keep any type of a log as to your attempts to contact and speak with Miss Hunter, Miss Hunter, good grief, excuse me, everybody, Mr. Hunter, during this time period of when you first received the vehicle?
Yes, I did.
And can you tell me what the Plaintiff's Exhibit number 2 is?
That is the phone, either calls or text messages when I attempted to contact Mr. Hunter to either let him know that his truck was done or any kind of communication that we needed in between that. And I talked to him, I think once on the phone, maybe twice in person.
How is it that you created that log?
It was on I've since switched providers from US Cellular to Verizon, but it was on my US Cellular bill.
So you just went through and pulled all the numbers for the dates and times.
Dates and times, yes. And then it says on there that it was 000, or that it was like 10 seconds or 12 seconds or whatever.
So on the May 23rd call, you made some notes.
This was actually in person, the 23rd at 8:20 a.m.
Okay.
That's when we talked in the back parking lot.
Okay, so the May 23rd is when the two of you talked regarding the injectors.
Yes.
And looks like you did mark 2 down. Is that correct?
Informed 2 injectors were bad, recommended replacing all 6. Nothing was said about possibly selling the truck, and that's why I recommended all 6. When we go in, I'm not trying to gouge anybody, and I didn't add any labor to that.
So your labor was for replacing the 2 injectors that
Yes.
he thought was going bad.
Yes. So in my experience mechanicking and with injectors and everything else, especially in a high mileage vehicle, you can go in, if you have one, most generally every other injector in there has the same amount of miles on it as that one does. So I will, if it's 2 in there, especially on that one, if it's a V8, I would do it on that whole side. I would recommend all 4 of that side. This is an inline 6. I recommended all 6 be replaced. And then at the same time, there is a pass-through harness that gets hot. And then you can also have problems with that. While we're already in there, it's only going to cost you the parts. It's not going to cost you any more labor. We should replace that as well. And he agreed to that. And so I went ahead and ordered everything, got everything coming, and repaired the vehicle.
Then these other attempts.
Excuse me just a moment. So do I understand correctly that you charged him for replacing 2, though you replaced 6 plus the harness?
Yes, ma'am. We're already there, and I just don't look at it that way. It doesn't take us that much more time to go ahead, and I'd already quoted that price for the labor, so we can go ahead and do that for the same amount.
All right, thank you. I just want to make sure I understood.
Yes.
And that was in regards to labor, Your Honor.
Yes,
Yeah,
for
the
labor,
labor.
just the labor, right.
Yes.
Right.
So you also, there's, as I recall, there are notations on your August billing or estimate that indicate that there was a battery, 2 batteries, and a starter that were replaced. Why did you do that?
We went out to start the vehicle, and it was completely dead. So I had 2 jump packs. I put a jump pack on each side. The vehicle wouldn't start. It would try to crank over, but it wouldn't. It didn't have enough juice to actually start it. So I pulled the cables off, tested the batteries. One battery had a dead short in it. The other battery was so low it would not take a charge. It was basically running off of my jump boxes to try and start the vehicle, and there's just not enough power there to do so. So at that point, I can't work on it. This was before we even started working on it. I can't work on it unless it runs. So I have to put batteries in it. I replaced the batteries, It does say to replace both. The other one wouldn't take a charge anyway. Says to replace both is the recommendation. So replace both batteries.
When you say says to replace both, is there some type of a
Yes, when
service manual or this
yes, when I go through my Napa Auto Care Center and I put a battery on the ticket and it sees that it has to, it recommends to replace both batteries at the same time. So, and it's just good practice, especially in diesels, to replace them both at the same time. So replace both batteries. Went to start it. It started to turn over and then stopped. So got underneath of it. I tried to tap on the starter, which generally, if the starter locks up, sometimes you can tap on it and it will unlock and you can get it to start and get into the shop. Tried tapping on it. It wouldn't start. At that point, decided it needed a new starter. It was getting power to the starter. It just wasn't starting the vehicle. Replace the starter and
Hold on a second, sir. Regards to starters on a vehicle of that nature, are they prone to sudden failures?
It can happen either way. It can drag on for a little bit. Sometimes you can tap on it. Sometimes you can hit the key 3 or 4 times and it'll start. And then sometimes you just go out and it just won't start.
Would you say more often than not, it tends to drag a little bit to begin with?
Generally, yes.
Before complete failure is
Yes.
such as that?
Generally.
All right, so you replace the starter, then what do you do?
Was able to start the vehicle to get it into the shop. Brought it into the shop, went ahead and scanned it again. Was scanned that 2 injectors were bad. And just basically to confirm my diagnosis. Confirmed the 2, went ahead and tested all the harnesses. All the harnesses were testing good, but with, I think it was 200, I can't remember the actual mileage on the vehicle. It had, I want to say 260 some thousand miles on it. So with the heat and cold, it was only a matter of time. So talked to him about, we'd already talked about the pass-through harnesses and went ahead and replaced and ordered those as well. I ordered those online, which took a little bit longer, but they're 3 times the price through Dodge. So I went ahead and ordered them online to save several $100s to the customer.
What would the prices of those injectors been if you'd gone with original manufacturers through Dodge?
OEM would have been pushing $700 to $800 my cost. That's with my discount through Dodge.
Okay. So going back to plaintiff's exhibit number 2, sir, outside of the in-person discussion where you said they should replace all 6 and you said he agreed to it, and the July 18th text said that he couldn't read the bill, what other contact did you have with Mr. Hunter?
0.
When you would call him on any of those dates listed on plaintiff's exhibit number 2, whether it be June 13th, 14th, 15th, etc., did his phone go to voicemail?
Yes, it would ring through and then like ring 6, 8 times and then go to voicemail.
So each time went to voicemail. Did each time you leave a message?
Yes.
Oh, that's what you've also noted on your sheet as well. And then it looks like there was, well, we've already gone through the text exchange. That was self-explanatory. Outside of Mr. Hunter's testimony today and perhaps statements that were made following contact by law enforcement, had he ever expressed to you that he thought the bill was wrong?
No.
Did he call you in late July and say, hey, what's going on here? This isn't what we agreed to?
No.
But he showed up on August 5th and took the vehicle?
Yes.
You still have the keys to the vehicle?
I do. They're in my safe at my shop.
Your Honor, I'd move to admit plaintiff's exhibit number 2.
You said 2?
Yes.
Okay,
Or
2.
did I already do
Objection.
that?
Okay, exhibit 2, Mr. McClendon, you objection?
I thought it was already admitted, but no objection.
I think I actually did 1 and 12, and then and I may have done
12
2.
were admitted. 3 is now admitted then.
And so now moving to exhibit number 3. Can you identify that for me, sir?
That is the mechanic's lien sale affidavit.
And in that regard, did you reference that document a little bit ago to refresh your recollection regarding some of the specifics on the vehicle and its mileage?
Yes, I did.
And is this something that you prepared while you still had possession of the vehicle?
No, it was after. It was the Monday, which would have been the 7th, 8/7 of 23.
All right. And this was basically your kind of a first started attempt to go through and try to get some type of lien security on
Yes,
for your work.
Yes, either lien on the vehicle or payment for services rendered.
Yeah, I moved to Plains Exhibit 3.
Objection to 3? Mr. McClendon? Still muted. Okay.
No objection.
Okay, plaintiff's exhibit 3 is admitted.
Okay. Now, but I moved to Plaintiff's Exhibit number 4 and 5, just to save time. What are those, sir?
The first one on number 4 is the new starter from Napa and the valve cover gasket from Napa. And then on number 5 is the batteries from Napa.
So these were some of the items that, well, at least the batteries and the starter were the unexpected.
Yes.
Moved to that Plaintiff's Exhibit 4 and 5.
Mr. McClendon, any objection to 4 and 5 submission?
No objection, Your Honor.
Number 4, plaintiff's exhibit number 4 is admitted, as is plaintiff's exhibit number 5.
Next, I'm going to hand you what's been marked as Plaintiff's Exhibit 6 and 7.
Exhibit 6 is the fuel injectors, quantity of 6. And Exhibit 7 is the intake manifold gasket.
And again, those are at cost, and then Napa, as you said, basically adjusts, but basically they set the price on the work
Yes.
and the charge for the material. Your Honor, I would move to admit plaintiffs 6 and 7.
Mr. McClendon, any objection to plaintiffs 6 and 7?
May I go on a quick voir dire, Judge?
Sure, go ahead.
Just so we're fresh on the topic, Mr. Strickland, you said you were a Napa dealer earlier, correct? Or a
Yes,
Napa first. So may I ask why are these from O'Reilly? They say O'Reilly on the top.
The injectors from Napa were unavailable for the OEM new, and they were available through O'Reilly's. I'm also an O'Reilly's first call tech, which I get the same basic things from them. The only benefit I get from the Napa Auto Care Center that I don't get from O'Reilly's is I have a tow service. So if they call back in and we've done something and it's failed, then the Auto Care Center would take care of towing them to the closest shop and having it repaired underneath Napa's umbrella, I guess you would say. But O'Reilly's offers the same thing.
Okay, and so when you were creating this estimate, invoice bill, whatever we decide to call it, whose price did you go with? Did you go with Napa's price, even though you
It was
purchased the price from O'Reilly?
No, I input O'Reilly's price into my Napa Auto Care Center, and then the matrix automatically upcharges to get my profit margin.
Okay. So what price did you, or so you're saying what price did you input into there? Just walk me through it. So you inputted O'Reilly's price in there. What
Yes.
price did you put in there? We'll just go with the
401.28.
injectors. 401.28. And then
Yes.
it came back with an amount of $693 as your upcharge? Or about?
Yes, $693.74.
So is it standard to upcharge by 50 to 100% on most of these parts as seen here?
That is a question for Napa. I don't have anything to do with the matrix. That is something that is built into my computer system that all I do is enter the part number and then it automatically does everything else.
I'll reserve my other questions on the matter for cross-exam, Your Honor,
All right, thank you.
but no objection to it being admitted.
Okay, plaintiffs exhibits 6 and 7, both are admitted.
Plaintiffs exhibit 8 and 9, Mr. Strickler, do you recognize those documents? Can you identify them?
Yes, I do. That is for the pass-through harnesses that I got online for the injectors. And then one of those is a refund because something happened and it didn't show up or something, and I had to get a refund on it.
So that was an original Dodge OEM part.
That is an OEM part that I got online, not directly from Dodge. Those coming from Dodge would have been $400 per harness.
All right, then moving to plaintiff's exhibit.
Just a moment. Okay, so you ordered those, you didn't get them, and so you got a refund?
No, I ordered them. There's two. There's exhibit 8 and exhibit 9. I only needed 6. I ordered and I couldn't get. I think they only had maybe 4 or 5 available, and I ordered 6. So they sent me a refund on the one that they didn't have, and then I had to order the one from a different supplier online.
Okay, thank you.
If I didn't do so earlier, Your Honor, move to admit 8 and 9.
Any objection, Mr. McClendon, to 8 and 9 being admitted?
Just another quick voir dire to figure out where these even came from.
Very well.
Mr. Strickland, where is this a screenshot of? I mean, I can see we have an injector harness on there, but I have an email showing, frankly, some foreign country, probably Chinese parts.
I guess I don't understand your question.
So where is this a screenshot from?
It's from it's a screenshot from, or it's a scan. No, screenshot from my computer.
And what website were you on at the time?
I couldn't tell you. It's been over a year ago.
So this could be just some random part off the internet, not necessarily an OEM part.
No, it says right on it that it's a Cummins Dodge OEM part for a 0305 injector wiring harness.
Which page are you looking at? Because I don't see anything.
Number
I see
9.
one that says OEM. I see one that says
Exhibit
OEM.
number 9.
Okay, on Plaintiff's Exhibit 8, there's nothing on there that says OEM, correct?
No, I don't see anything that says OEM.
And you would agree with me that at the top of the page, there's an email there that, or forgive my pronunciation, but Zai Tong Parts?
Yeah.
That sounds Chinese.
Yeah.
And on the next one is Ho Diesel on exhibit 9.
Yeah.
Okay. So you don't remember where you got these parts from, though?
It says right there on the sheet. It was an online part.
It was just someplace online, is what you're telling me.
Yes, an OEM part online. Yes. Otherwise, it would have been $400 some odd dollars per, which would have been another $2,400 onto it. But that's my cost from Dodge, so it would have been upcharged from that as well. So it'd have been over $2,400 just for the pass-through harnesses. When I got the same thing online that came in an OEM box for a fraction of the cost.
And did you go through the same process of putting in these prices in for your upcharge calculator from Napa?
No.
No. So what did you charge him?
The pass-through harnesses were $192.08 per, and I did. So there was past 300, 194.65. Sorry.
Okay, for a total of 332.
For a total of 583.95.
So there are three of them. And I'm just trying to clarify here to the, because there's questions regarding authenticity of this, Your Honor, I believe, of what these invoices are even referring to at this point.
Well,
I mean, yeah, they're parts that he purchased, but I'm just trying to draw the line here because where does he come up with the $500? Because I see no quantity purchased on either of these.
I think on plaintiff's exhibit 1 under item info, my copy says 3 pieces, 3966805 fuel injector wiring harness for 03-045.9 L Dodge, $336. Does yours show that, counsel?
It shows for $336, but he
But-
did just state that he didn't provide any upcharge service on this.
Okay, but I
And
thought
so,
it didn't say how many pieces, and it says 3 harnesses. Is the way I read 3
right,
pieces.
correct. Sorry, I didn't phrase it right.
Okay, and then on plaintiff's exhibit 9,
Injector 194.65.
I'm seeing, I can't
These are
quite,
the harnesses.
there's
They
a
refunded part
sphere,
of that back.
Yes.
but it looks like,
6 minus 657 plus 69.
all right, okay, so someone was talking, I think did you have some other question than that, or did I misunderstand the question? I mean, it looks to me like it shows the quantity out. But if you want to restate your question,
Yeah, I'll restate. I was getting on a
Okay.
tangent.
all right.
So just to kind of start from a little bit before. So did you plug any numbers into the upcharge calculator, Mr. Strickland?
On the harnesses?
Yes.
Yes, on the harnesses I did.
Okay.
I can't
And
sell
then-
parts at cost.
Obviously. And so how did you come up with your figure for the fuel injector harness?
It was a percentage. I can't tell you. I can't remember what it was.
You just cut it up by thirds and then plugged it in.
Yeah.
So you did the 336 by 3, plug that in, and that gave us a 194 a piece, and then you got the 583 through that.
Yeah.
Okay. The same thing for the injector wiring harness.
No.
So
The
what happened to
injector,
that one?
anything that comes from Napa and O'Reilly's automatically generates into my computer. Anything I buy online, I can't plug that into my computer because my system doesn't recognize it. So I have to come up with the pricing of it.
And so how did you come up with the pricing of that? Of the
Percentage.
injector wiring harness for $69 as seen here in Exhibit 9?
Well,
That's so it takes 6. I ordered 6 from one vendor. They didn't have 6 in stock, so they refunded me for the 1. Then I found another one online, another OEM one online, and I purchased it. That's where the $69 comes from. Then you put all 6 of those together, and then you upcharge it by a percentage, and then you divide it. There's 2 per harness. There's 2 cylinders per harness, so you divide that by 3, and that's how you come up with the final number.
Okay.
Which is still probably just a little bit higher than one of those harnesses would have come from OEM from Dodge, and it's the exact same harness.
Your Honor, I have no objection otherwise.
All right, well, I thank you for asking those questions. Some of those I had. Those are admitted as plaintiff's exhibits. Let's see. 9 and, let me see, 8 and 9.
correct.
Admitted. Mr. Dean, I think it's back to you now to finish with your
Okay.
examination.
Show you next what's been marked as place exhibit number 10. Can you tell me what that is?
Okay, so this kind of explains my matrix to a certain extent. I don't understand how it works, but I went up and I looked the exact same part number up as what we used in Mr. Hunter's truck. I looked it up, I believe it was a day, maybe 2 days ago, and did just a regular ticket for a John Smith, nobody. I downloaded the exact same injector that I put in Mr. Hunter's truck, and I uploaded it into my system. When I uploaded it into my system, it automatically generated the price. It automatically generated everything. And then that's what come up in exhibit number 10. So evidently, when I did this job in early of 23, the pricing was considerably lower because now the injector has gone up.
And Your Honor, essentially, plaintiff's exhibit number 10, even though we wouldn't typically do this way in a court case if we were in person, but since we doing this via Zoom, essentially it's meant as a demonstrative exhibit, but that's the reason for it, just to show how that system works. Yeah, plaintiff's exhibit number 11, Your Honor, which is also meant for demonstrative purposes as well. Can you tell me what that is, Mr. Strickler?
That is the exact same injector. It's a new OEM. It's not OEM. It's not a Dodge part, but it's OEM certified. So it's the same. It meets the same certifications that Dodge has if you were to put their injector in.
And again,
That's what you ordered online for him.
No, this is the Napa. This is Napa's. This is the auto care center part of it. So if I was to buy this injector today, that price, which I gave $401 and some odd cents for in 23. Now, if I was to buy that injector, it would cost me $527. Okay, so 401 to 527. That's how much the prices come up. Also, when I put it into my matrix, it came up with the 401. It came to 693.74. With the 500, the injector today, if I was to buy it today for 527, it would go on to an estimate bill today for $810.78. That is the upcharge matrix that Napa Auto Care has put into my computer.
okay, so
are you moving to admit those, Mr.?
yes, Your Honor.
I've interrupted so much. Mr.
11, or excuse me, 10 and 11, and then I think that covers all of our exhibits.
Mr. McClendon, any objection to plaintiff's exhibits 10 and 11?
No objection, Your Honor.
All right, plaintiff's exhibit 10 and 11 are admitted. Well, has previously been admitted. Mr. Dean?
All right. Mr. Strickler, was there anything unusual about the way this repair went? Anything that took additional time? Or was this a standard injector replacement on this style of diesel engine?
As far as the injectors go, it's straightforward. It goes just like they always do. Nothing out of the ordinary other than the batteries and the starter. Everything was normal.
Okay. So, Mr. Hunter, did he provide you attempt to provide you with a check?
He did.
When did that happen and how did that happen?
On August 8th, I tried to get the sheriff's department to do a theft of services. Officer Cordell came to my shop and we talked about it. And he said, and I won't even say what he said other than he wanted to try and get a hold of Mr. Hunter to try and see if he would just pay the bill to where they didn't have to file any charges. So he said to give him 24 hours. So that was on the 7th. On the 9th, he showed back up. He said he would be back after 5 on the 9th. He showed back up after 5 on the 9th and tried to give me a check for $2,000. I refused that check just because the way things had already gone, I wasn't going to accept partial payment. I wanted payment in full. And to be completely honest, I probably wouldn't take a check anyway at this point. And at that point, they said that they had decided that it was going to be a civil matter.
It doesn't,
Okay.
in regards to that, to those decisions, that's not what I'm asking you.
Okay, sorry.
So going back to refusing that check, are you simply asking the court to grant you judgment as prayed for an amount of $7,876.41?
Yes, I am.
That does include some storage fees and interest, correct?
Yes, it does.
And if the judge, if the court would find that interest at that rate was inappropriate, are you at least asking the court to impose prejudgment interest rate set by statute?
Yes.
And essentially, the billing that you're requesting is as set forth in plaintiff's exhibit number 1, correct?
Yes.
Now, I don't believe I have any further questions at this time.
Mr. Dean, if you would please summarize, based his testimony, what it is that he's seeking.
Yes, Your Honor. We have essentially the plaintiff is requesting that the billing as submitted in the plaintiff's exhibit number 1, which has essentially claim for $7,876.41 be granted. That does include $1,200.20 that are represented by 50-day storage fee and 30-day 10% late fee, which is just 10% interest charge. The court disagreed with that portion of the claim on the interest. We would ask in the alternative that the court grant prejudgment interest on what's known as on what is a liquidated known amount that's been in this building from basically the date that Mr. Hunter was advised that the vehicle was completed, which was back on June 13th of 2023.
Very well. All right. Any other questions on direct, Mr. Dean?
No further questions on direct, Your Honor.
All right. Mr. McClendon, cross-examination.
So we're going to rewind a little bit here, Mr. Strickland. Let's go back to your conversation with Mr. Hunter originally. So can you go over it again? So start from the top. You saw Mr. Hunter and you said you thought it was an injector, correct?
The first time I talked to him, he was driving through the back of the shop and I happened to be in the parking lot, and he asked me if I would be interested in working on his vehicle. And he thought that there was an injector bad, and I gave him a kind of a time frame that I could have the vehicle, and then kind of a time frame it would take to get the work completed. He said that would be great. I gave him a time to bring the truck up. He brought the truck up and we talked about it. Basically informed me that he thought it was an injector.
Okay. And did you at any time agree that it might be an injector as well?
Not until after I scanned it.
Okay.
Like I said, the pass-through harnesses could also be a problem. At that point, the pass-through harnesses tested fine. And it turned out that it was 2 injectors that were bad after diagnosis.
And was Mr. Hunter there at that time, or was this after he had already left the shop that you'd done your?
He had already
diagnosis?
left. At that time, I think we were 2 to 3 weeks behind. We'd had a couple jobs go sideways, and I just have a 2-bay shop, and it was nothing was working right at that time.
Right. So when you talked to Mr. Hunter again about the work to be done, what did he say to you?
I informed him that there was 2 bad injectors, and that basically on a high mileage vehicle like that I would recommend to do all 6, just because if I wasn't going to charge him any more labor, but while we're there, we should do the other ones. It's only going to be parts that we should do that because you could get a week down the road and it could drop one of the other 4 injectors. And then we'd be right back at it again, doing the exact same labor claim to fix another injector. So it's easier. It's better for the customer, everything. If we do all 6 at the same time, that way they're all under warranty. Everything is taken care of.
And did you provide him any kind of pricing as to what that might look like?
No,
None at all.
no.
You didn't say, oh,
We
it might
talked
be
about
$400.
the first couple injectors. We did talk about pricing on that.
And what did that look like?
I couldn't tell you. It's been over a year ago. I know it wasn't $400 because that's what I get for the injector, and I can't sell it for what I get it for. That's what I got it for at that time. Let's put it that way.
So yeah, you're telling me here that you had no suggestion as to what the price might wind up being?
Objection, mischaracterizes the testimony.
I think it's a fair question. I'll overrule.
I did not do an actual estimate on it. No. If in discussion we talked about pricing, then I can guarantee you that it would not have been what I give for the part. I can't tell you what I would have priced that part at that time because it's been over a year ago. But I can tell you it wasn't $400.
So even that being said, did Mr. Hunter provide you with any kind of idea of what he wanted to spend?
No.
On this repair?
Nope.
He didn't say he didn't want to spend a whole lot of money?
No.
And just so we're clear here, Mr. Strickland, not to dive into your finances or anything, but do you think that 7,500 or even the original $6,000 bill, would you consider that not a whole lot of money, or do you think that's a fair amount or a larger amount?
Considering that if you were to have it done at Dodge, it would have been $9,000. I consider it fair.
But if you were saying you didn't want to spend a whole lot of money on the truck, would that be a whole lot of money?
That was
Would
never
that be
said,
more than you
so.
would that be more than you expect to spend?
In my opinion, is that what you're asking for?
Yes.
In my opinion, I would do all 6 because I'm a mechanic and that's the way it should be done.
But if you weren't a mechanic and you were just trying to get the truck up and running again,
But I am a mechanic and I wouldn't do it that way.
we'll move on, Judge. And just out of curiosity here, on the phone log you provided, why did you just write down the dates instead of providing the actual phone bill? Because you said you had the phone bill.
At that time, I was through a different provider and I was just going off of what I downloaded or I was looking at on my phone.
So you had to download it and you had it on your
No,
phone.
It was on my phone. I've
So you
switched
could have taken a
providers since
screenshot
then.
of it.
It was on my phone.
It was on your phone, so you could have taken a screenshot of it.
I guess I could have, yes.
And so this is important stuff because you thought to write it down, but you didn't think, hey, the actual bill might be a better form of proving this up.
Well, in hindsight, yes, but this is the first time I've actually had to go to court to get paid for a bill. So I didn't know at that time kind of how this whole process worked. So I was just taking the information that I had and documenting it in the best way that I knew how at that time.
And you didn't think it'd be easier to just take a screenshot and save it on your phone in your picture roll?
I'm not a very tech guy, so no.
Okay. So let's go to the bill that you sent Mr. Hunter. Would you agree with me that that's not a complete picture of the invoice that you sent? We'll refer to plaintiff's exhibit 11, Your Honor. Is that not a complete copy of the invoice? It shows the prices, but it doesn't
Are you-
include all words.
Are you sure you
provided.
don't, excuse me, are you sure you don't mean plaintiff's 12?
I said 12.
Oh, I thought you
Sorry.
said, I'm sorry, I missed.
Sorry, Your Honor.
No problem, okay. You may need to repeat the question there, counsel, since I
Sorry.
interjected.
So you would agree with me that that's not a complete copy of the invoice, correct?
No, that's a picture of the invoice that I could fit in, and I could fit all the main billing information in and make it large enough to where it could be seen.
Well,
At this point, when I sent this picture, the lower half of that estimate bill, whatever you want to call it, had never come into play. I was not going to charge him the storage fee. I was not going to charge him the late fee. I was not going to charge any of that. I just wanted him to take care of his bill. So that's why he got a cropped copy of that bill. That's what he owes. Then when he couldn't read that and wanted me to send the hard copy, I sent the complete hard copy, and I highlighted the bottom part where it says the storage fee part and the late fee part. I highlighted that to where he would see that I was trying to be upfront about it, and I wasn't going to charge him that. And then after he came and got the truck is when I added the late fee, the storage fee, and everything else to that bill, to the original amount of that bill.
so you decide you weren't going to charge him in the originally, and then you decide later on to charge him.
Yeah, if somebody comes up to my lot on a Saturday with a spare key and takes a vehicle that I have $6,000 and some odd dollars invested in, then that's going to kind of, and it's set there for that long with no communication, then yes, then now you by that, it was due. I was just trying to be nice and not going to charge that. But if you're going to let it sit there for 50 days and then come get it with a spare key and not even call or return phone calls for 50 days, then yeah, you can pay the late fee on that. This is also the first time I've ever charged a late fee or a storage fee in almost 6 years of service in my own shop.
Here. Have just a minute to get this over to me, Your Honor, so I can send it to. I have an exhibit here I'd like to introduce.
I do have one that you were offering for the Bosch fuel injector. Are you sending another one?
Yes, it's a new one that I didn't have originally.
Right, so do you want this first one that you sent to be, what, defendants A? And that one defendants B?
Yes, Your Honor.
All right, thank you. If you'll send that to
Your
me.
Honor, we've discussed these exhibits. Mr. McClendon and I have had a chance to discuss these exhibits over the last couple of days. Just kind of preparing for today or seeing if we could resolve things, but no objection to them. So
I'm gonna text you. I'm gonna text you a picture of it here, Paul, so it hopefully comes across.
So you may not have B yet, Mr. Dean?
No. Sorry, Your Honor.
That's all right. I believe it was mentioned.
Okay.
This one wasn't. Sorry, Paul.
Okay. I'll look at it here just as soon as it pops up.
Well, do we have anything other than, does Mr. Dean have anything marked as B, or can I go ahead and reserve B for the one that's coming through?
No objection.
Can we reserve
No.
the one coming through?
Okay.
No objection.
All right.
My phone's messing up now. What?
It's always something, isn't it?
You know, I could go print this right now.
Okay, I just emailed it to Missy.
And there's no objection to it, Mr. Dean?
No objection.
Okay. So A and B will be admitted, although you haven't offered A yet. Do you want to go ahead and offer it or want to wait? why don't we just wait? Because you may not want to offer it when it's said and done, but
Yeah.
I've marked the Bosch fuel injector exhibit as defendant's A.
Okay. All right, let's see. I'll see if I can. I'll see if I can find a screenshot so I can screen share this with the court. That way, should have just done that originally. That would have made things a whole lot easier.
And I like to have the hard copies
I
too,
know.
so thank you.
It'll be coming.
All right. But you can proceed with screenshot.
Hopefully, a much clearer version will be coming through, but
Yeah,
this will be marked as Exhibit B, state or plaintiff or defendant's Exhibit B.
very well.
So Mr. Strickland, is this a copy or a screenshot of your Facebook page?
Yes, it's Strickler, and yes, that is a copy of my.
Strickler?
That's a screenshot.
Sorry, excuse me.
All right.
And
I'm not reading that very well, counsel, but you're saying this is, B is a copy of Cliff's Gas and Diesel Repair, what is Facebook or a text?
That's what my
It's
clients,
a-
it's Facebook. That's what my clients identified it as, Your Honor.
Yes.
Okay,
And I get for if the court would like, basically it's a screenshot of the bottom part that's posted on Facebook. It only shows that highlighted portion of the bill indicating the storage fee, 10% late fee. And then there is text that says, I have been very laid back about handling this the way the way a business is supposed to handle things, but things are changing today, and I'll probably have a few cars for sale in 90 days or so.
I believe that's the same language taken directly from the bottom of plaintiff's exhibit 1 that has been cut off of plaintiff's exhibit 12.
Right, Your Honor.
Okay, all right. So even though I don't have the actual exhibit, I have the actual verbiage and from the exhibit 1.
yes. And so just to prove it up some more, so this is a copy of your Facebook page, correct, Mr. Strickler?
Yes, it's not my Facebook page. It's my shop Facebook page.
The one for your shop.
Yes.
Your Honor, at this time I move to admit defendant's
And
exhibit
it's
1.
B. I think
Exhibit B.
Mr. Dean, you said no objection to defendant's exhibit B.
That's correct, Your Honor. No
All
objection.
right.
Okay, so Mr. Strickler, earlier you stated you'd never had the problem of anybody not paying earlier, right?
Yep.
And so what is the timestamp on that post?
That is February 15th, 2023. I didn't say that I hadn't had people had problems paying. I said I have never charged a late fee or a storage fee, is what I said.
But had you had problems with people coming in and paying?
Yes, I have.
So when you went to start the vehicle, you said it was missing batteries or it needed new batteries, correct?
Yes.
You don't keep any kind of shop batteries around for vehicles that may, need a battery and you want to just pop one in real quick. You just go buy a new battery every time.
No. I have 2 jump boxes that I can use to jump a vehicle on a diesel truck that is basically running off of jump boxes that are designed to jump cars. It didn't have enough power to jumpstart a diesel truck.
So did you ever call Mr. Hunter and say, hey, we need to replace batteries first?
No,
So you just went in and spent, I believe it was $400 on batteries and didn't care to tell a guy you were gonna do that?
well, in order to do the repair that I needed to do, that was authorized to do, I had to have it running. In order to get it running, it needed batteries, and then as it turns out, it needed a starter as well.
But isn't it possible that Mr. Hunter probably had batteries, at his house ready to put in there?
Anything's possible.
Isn't it, I mean, would you like, what's your preference of batteries, Mr. Strickler? Do you have a preferred battery that you use?
If it's for the shop, I go through the Napa store.
Mm-hmm. But do you have a preference personally? Would it be different possibly?
No, I have 3 Napa Legends in my boat. I have 2 Napa Legends in my pickup.
Mr. McClendon, do you need to leave
Yeah.
the screen shot up?
Sorry, no, Your Honor.
Thank you.
Isn't it possible though that Mr. Hunter thinks Napa batteries are not good and thinks they're junk and doesn't care to have them put in his truck?
That's possible, yes. And if that's the way he wanted, if he would have replaced those batteries and brought them back to me, then I would have taken them off the bill. But that didn't happen either.
Did you call him to ask about the starter, if it was all right to replace the starter?
No, I did not.
So, Mr. Strickler, why didn't you call him? A starter is a crucial part of the truck. They can be replaced fairly often, wouldn't you say?
Once again, in order to get the vehicle into the shop to do the authorized repair, it had to be running. In order to get it running, it needed a starter.
Okay. But I guess you had no contact with Mr. Hunter, so you wouldn't know that the starter was still under warranty, did you?
No, I didn't have any contact with him from May 23rd until the 1st of July.
Partially, though, that is because you didn't try to contact him while you were doing repairs, though. Is that correct?
Yep.
No further questions at this time, Your Honor.
Any redirect, Mr. Dean?
I'll try to make it brief, John. So Mr. Strickler, in regards to repairs that you're making, if the repair's been authorized, essentially as you're going through to complete that repair that's been requested, you're going to repair any additional item that's basically becomes a component of getting the injectors replaced, correct?
If it affects the original repair to where I can't complete the original repair, then I would replace it or fix it, repair it as needed. And I have gone as far as people that have had a problem with doing that I have taken my labor off of that and just charged basically my cost on the part. But there again, we never discussed that because the vehicle disappeared.
And Mr. Hunter never came to you to say, hey, what's the deal with this starter? What's the situation with these 2 batteries?
No.
Mr. Hunter basically wouldn't speak to you following dropping off the truck and saying, replace the 6 injectors.
Yes.
And he did agree with you that if you're going to be in there, replace all 6, even though 2 of them are the only ones that are currently malfunctioning.
Yes.
And I wanted to be clear, I believe you you stated this to Mr. McClendon, but Mr. Hunter never said anything to you about him selling the truck. We got to keep it at a certain cost on the repairs, etc.
No.
And even though this is a diesel, or even though this engine had sent it to 260 some thousand miles. In regards to diesel engines, that's really not what we call high mileage, is it?
It's not at all. Mine has 210,000 miles on it right now.
Diesel engines, the Cummins diesel engine produced by Ram, or I guess this was a Dodge model at that time.
Yes.
What would you expect to be able that engine life on a diesel engine of that nature?
With proper
Objection
maintenance
calls for
and upkeep.
speculation.
Excuse me. Objection calls for speculation. Response, Mr. Dean, to that objection?
Your Honor, we have a 16-year mechanic who repairs diesel engines. Don't think that's probably calling for speculation.
Objection overruled. Please repeat the question.
He had already answered, Your Honor, that would not be considered high mileage on a diesel engine. And I asked how long, what type of life or mileage you would expect to get out of a Cummins Dodge diesel.
And I heard the answer. So next question.
Well, I actually don't think he actually got the answer out.
Oh, I'm sorry. I thought he did. Okay. I heard part of it. Go ahead.
I do have a couple trucks that we do for farmers that have 500,000 plus miles on them.
And in diesel engine world, that's not unusual.
Not unusual.
And Dodge Cummins engines, those are diesel engines. Those are diesel engines been around for quite some time. Is that correct?
Yes.
How long have those been around?
So the 5.9 was up until 07, and that started in 1996 to 07 was the 5.9, and then mid 07 to current is the 6.7 model.
And the Cummins engine, has that been, well, this particular engine, a fairly reliable and dependable diesel engine?
In my opinion, it is the best diesel engine made.
And that was the 5.9 that you think is the best, or was it the 6.7?
But either one, ma'am.
Okay.
The 6.7 is just the upgraded version of the 5.9. It's got more horsepower and it's a little more user friendly.
And going back to the original conversation, I think you had indicated to Mr. McClendon that there was some discussion, perhaps some discussion about costs, but you don't really recall that.
No, not the actual number.
And did Mr. Hunter tell you, well, before you touch a thing on this truck, you give me an exact to the penny cost on what this is going to run?
No, he did not.
What did he tell you to do?
At first, it was diagnose, figure out what was wrong with it. I diagnosed it. He thought one injector was bad. It ended up being two. We talked about the two injectors. I hadn't had a chance to call him when he came through the back of the shop, so we talked about it in person. Told him that the two injectors were bad, and that if it was my truck, that I would do all six. Just because if you got one or two, it could have been from if you're taking fuel out of a fuel tank like most farmers do at the farm. There's rust involved. There's everything else. So it could have had a blockage in the injector. We don't really know why it failed, just that it failed. So that can move on to injector 3, injector 4, injector 5, and 6. And then we're back doing the same job. I've done this before where they wanted to stay cheap, and then we do it again in a month. So that's what I tried to explain to him. If you're going to do it, you should do all of them at the same time. I won't charge you any more labor. Let's just do it right the first time and be done with it. And that's when we talked about the pass-through harnesses as well.
And he agreed.
Yes.
I don't have any further questions, Your Honor.
Ray Cross, Mr. McClendon?
Just to clarify though, you said on your truck you would usually replace all six, correct?
If in any truck that comes through,
yes or no will suffice.
Yeah. If it was my
But
truck, that's the way I would do it.
But this is not your truck, right?
No.
Okay, no further questions, Your Honor.
Very well. Anything further from this witness, Mr. Dean?
No, Your Honor, plaintiff rests.
All right, plaintiff rests. Now, gentlemen, it is 12 o'clock. We had from 10 to 2 reserved. Mr. McClellan.
They spend the next 10 minutes discussing schedule and time frame and decide not to come back for a week or two. And at some point, you're going to have to pay more for an attorney than the original bill. I know for the business owner, it's principle, not to be taken advantage of. I'm guessing the customer probably feels the same way. But how much effort is it really worth, especially when you don't even try to negotiate and work it out in person? You just automatically jump to legal options? What would you have done in this situation? Honestly, tell me in the comments. I'm really curious how everybody else would have handled it, because I don't necessarily react to these situations the same way as the majority of people.
All right, Judge, I've got that message out. I'm just gonna wait to see if I can get a quick response back.
Thank you. We had a couple of exhibits kind of informally handled throughout last half of the trial. This copy of the Bosch fuel injector, I'm showing that it was defense A admitted. Is that what you two are showing?
What I recall, Your Honor, yes.
Yes.
Okay. And then I have what is defense exhibit B, copy of plaintiff's Facebook page doing business as Cliff's Gas and Diesel Repair. Folks have that as B.
Yes, Your Honor.
And what, I'm not showing that admitted. Did you show it admitted, either one of you?
Which one was that again, Your Honor?
It was the one of the Cliff's Gas and Diesel Repair where on his Facebook, he copied his notice of storage, that he's gonna start collecting storage.
I remember it being presented. I don't recall as to whether there was a request for admission or.
I'm showing that it hasn't been, maybe we are waiting for another witness.
I
And
thought
then
we had admitted it because I used it to attempt to impeach Mr. Strickler.
Your Honor, and I have no objection just considering it admitted. I think it was probably requested to be admitted. I know I didn't have any objection if the request was made. I'm fine with the court admitting it right now, so we don't need to go back over it again. I mean, I don't think any additional witness needs to be called. My client, as I recall, acknowledged that was his Facebook post, and Mr. Strickler sitting next to him shaking his head yes. So.
And then somewhere along the line, we've been given a blue page, maybe it's just blue by happenstance, but it's captioned Greenwood County Sheriff's Office Supplemental Narrative. I don't think that's even been introduced, has it?
That would be testimony that would be coming from Sergeant Cordell. Mr. Cordell just said, "Oh, I forgot. Yes, got to find the link." I'll go screenshot the link to him real quick just to make sure. Hopefully that'll help him a little bit. Okay. That's done, Your Honor. Hopefully that'll
Okay.
take care of it.
So he's going to be joining us very shortly, it sounds like.
That was the impression I got from his text anyway. He said, "Oh, I forgot. I need to find the link." So now I've sent him the link. So that should get him to us sooner rather than later, I would hope.
There he is. Good morning, Sergeant Cordell, and welcome back.
Morning. Sorry about that. I forgot about, I'm got a jury trial today, so.
And you had some training. We knew you were very busy and occupied. So Missy, I think we can go on the record now. We are on the record in the 13th Judicial District. This is District Court of Greenwood County, Kansas, case number 2023 LM81, Cliffs GDR Inc. versus Scott Hunter. All parties appearing as before when we recessed on May 16th, 2024, after the first day of bench trial. Paul E. Dean for the plaintiff, who also appears in person by owner Cliff Strickler, and defendant appearing in person, that is Scott Hunter, as well as by and through his attorney, William McClendon. We left off on May 16th, 2024, with the plaintiff having called witness 1, Scott Hunter, and witness 2, Cliff Strickler, and admitting exhibits 1 through 12. The plaintiff then rested. We were at the noon hour and continued to today. So Mr. McClendon can begin his case. Are you ready to proceed, Mr. McClendon?
Yes, Your Honor.
And Mr. Dean, you're ready?
Yes, Your Honor.
Very well. Please proceed to call your first witness.
Your Honor, the defense calls Sergeant Michael Cordell.
Sergeant Cordell, please raise your right hand. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, ma'am.
Thank you. Please proceed, Mr. McClendon.
Mr. Cordell, what's your position with Greenwood County Sheriff's Office?
I'm the patrol supervisor for the sheriff's office, the patrol sergeant.
And how long have you been working for Greenwood County?
Approximately 8 years.
And did you have any prior law enforcement?
Judge, are you having a hard time hearing?
I am. I was just getting ready to ask you that question. Can we crank that
Mr.
microphone?
McClendon, for whatever reason, I'm hearing Sergeant Cordell, and he must be hearing you okay, but
It's
very light.
getting very quiet sometimes.
Okay, Mr.
Yeah, Mr.
I'll try.
McClendon, very quiet now.
I'll try to point my microphone closer to me.
Very good.
That sounds much better.
Okay. Let's see, where was I? Did you have any prior law enforcement experience before that?
Yes, I've been law enforcement full-time for approximately a little over 20 years.
20 years total. Okay. Mr. Cordell, do you recall what happened on August 7th, 2023?
Yes.
Would you care to explain what you encountered?
I was contacted by Mr. Strickler, who wanted to make a report of a theft of service because a customer had come in and picked up their vehicle without making payment for the repair stuff.
And who was that customer?
Sorry, I'm actually manning the metal detector at the courthouse during this jury trial until I testify, and so I don't have my computer with me. Scott Hunter, I believe.
Let's see. I don't know how I introduced the document. I would. Let's see. Your Honor, may I introduce a narrative?
You can do that. You can screenshot.
Sure.
Maybe Missy has it to screenshot. Missy,
I can
Are
share
you
it.
offering it for basically refreshing recollection?
Yes, Your Honor. Yes, Paul.
No objection.
And I will
Okay, so
admit it.
okay,
eventually.
but you're using it just to refresh the officer's memory since he doesn't have his file, or are you wanting to?
Yes.
It's an exhibit.
Both eventually.
Okay.
Just for the refresher now.
Your Honor, if it's going to be offered as an exhibit as well, I guess technically I don't really have a big objection to that. However, I know this is a bench trial, but I would still I believe that the last paragraph, because it includes officers' conclusions as an opinion regarding law, which is basically in the court's purview at this point in time, that should not be considered as evidence to be presented in the case. Because that is an opinion on a legal decision. And that's what we're here for the judge to make a determination.
So there's no objection to admitting it beyond just recollection of memory refreshed, that
Right.
it's an exhibit absent. Now, how are we marking these? I show a front and back. What do you folks have?
There's 3 pages.
Okay, I'm missing a page, I think. Missy, do you have all 3 pages of Sergeant Cordell's narrative?
I don't know that I got that.
If Mr. McClendon, you can,
Do you have a door you can forward that real quick, William? Otherwise, while you're doing if you want to ask him some more questions, I can scan this real quick with my phone and forward it to Missy. If that's
if Missy gets it, she could probably run a copy down to the deputy.
It's on eFlex. I know
Is it?
that, and I can
Maybe that's
email
what
it
I
to you
saw.
here real quick.
Okay.
Okay, it's on eFlex in this case. I can print it out real quick.
If you could run it
Yeah,
down.
I'll
Sergeant
send it
Cordell.
to you right now.
My apologies. I was very prepared last time, and then this time I'm got so much going on, and now I'm doing courthouse security that I don't even have my computer with me.
Last time you waited 2 hours and we didn't call you, so.
Hopefully they're not out asking you to check parking on violations in front of the courthouse next in your spare
Yeah.
time.
Uh-oh.
Yeah, with all that spare time.
Okay, I emailed a copy to all of you right now,
Okay.
just now, so it should be coming through.
Let's take, either proceed with questions of another nature that he can remember, or just give him a few minutes to catch up with that. I'm sure it would be under 5 minutes for him to get a copy. All right, Sergeant, I understand you have a copy of your report to help refresh your memory. Is that correct?
Yes, ma'am.
All right, then Mr. McClendon will be back on the record, same parties appearing as before. And Sergeant Cordell still under oath, so please proceed.
Officer Cordell, who was the dispute between?
It was Mr. Strickler and Scott Hunter.
And what was the dispute about?
Mr. Strickler stated that Mr. Hunter had come and picked up his vehicle after repairs were made. He had not made payment for those repairs. So that was
Just
what
a
he was
little-
reporting to me at the time.
Excuse me, Deputy, you're getting just a little garbled there. Were you able to track that?
Oh, sorry about that. I'll try to talk louder.
Well, I don't know if
Mr.
it's the
Strickler
louder or
stated
the
that he had
recording. It may have just been the recording making it garbled.
I think actually, Sergeant Cordell, that perhaps the Wi-Fi service dropped just a little bit in bandwidth because the picture froze and your audio became a little bit garbled.
Okay, I'll repeat that. Mr. Strickler had advised that that he had performed work on a vehicle at the customer's request, and that the customer had not paid for the work that was done, and that he had come and picked up the vehicle at night after the business was closed without making payment.
And what kind of work had been performed on the vehicle?
I was provided a copy of a form that showed that 6 injectors had been replaced, 3 pass-through harnesses. Let's see, it was 6 fuel injectors, a valve cover gasket set, 3 injector pass-through harnesses, 2 Napa batteries, and a starter, as well as the labor for those associated items.
And what was the total cost on?
The total listed for parts was $5,497.87, labor of $1,675.20, shop supplies of $20, sales tax of $683.34, and a total of $7,876.41.
Did Mr. Strickler have any kind of record that he had tried to contact Mr. Hunter?
Yes, he had a handwritten list of times he stated he attempted to contact Mr. Hunter regarding the truck and getting payment for it.
But this is just a handwritten list, nothing, on his phone going back and showing you the number or anything like that.
Correct. It was a handwritten list of attempts to contact Mr. Hunter.
Did you contact Mr. Hunter later that day?
I did.
And how did that discussion go?
I contacted him and he agreed that he had removed the truck from the property. He disputed the amount that was due for the repairs. He told me that he had talked to Mr. Strickler previously about the 2 fuel injectors that were bad and agreed to have those replaced, but he stated that he did not agree to doing all 6, didn't agree to the pass-through harness, didn't agree to replacing the batteries, and didn't agree to replacing the starter. He also told me that he doesn't use or like Napa batteries and that he would have never agreed to putting those in the truck.
Did Mr. Hunter allude to any kind of um, previously agreed upon price?
He said that he estimated that it would cost approximately $2,000 and that he had no problem paying for labor and parts because he wanted the shop to be able to make money. But he didn't think that it should have cost more than $2,000.
And did Mr. Hunter state why he decided to go pick his vehicle up?
He said that the as he stated, the estimate that he received indicated on it that any vehicles that were left on the property more than 48 hours after the repairs were made would incur a storage fee. So he didn't want to incur a storage fee for leaving it there. He also stated that there was a stipulation on that document that said that there would be a late fee for any bills that were outstanding beyond 30 days. So he assumed that that was indicative of, having 30 days to pay the bill without incurring that penalty. So he didn't think that that meant that payment was due at the time that he picked up the vehicle.
And so Mr. Hunter said he didn't think he had to pay immediately. Did you contact Mr. Strickler after your discussion with Mr. Hunter?
I did.
And what did that look like?
Mr. Strickler stated that he had gotten approval for the 6 injectors and the pass-through harnesses. He did state that he did not get approval for replacing the batteries or the starter, but that those needed to be done before repairs could be made. But he did state that he had definitely gotten approval for the 6 injectors and the pass-through before he did that work.
Do you know if Mr. Strickler got any kind of signature or anything prior to completing the work?
He stated that he did not get a signature on the estimate before doing the work, that he had gotten approval over the phone.
Did Mr. Hunter try to make any motion to rectify this wrong? Did he try to fix this problem?
Yeah, so because he believed that the appropriate amount for the repairs was $2,000, he agreed to write a check for the amount that he felt was due. The day after our conversation, he did give me a check from Cedar Crest Farms LLC for $2,000 made out to Cliff Gas and Diesel. And then I brought that check to Mr. Strickler the following day.
And what did Mr. Strickler do with that check?
He declined to accept the check because his concern was if he accepted partial payment that would negate his ability to collect the full amount.
And were any charges brought against Mr. Hunter in this matter?
No,
And why is that?
Objection, Your
my-
Honor. That is a
Sorry,
legal standard.
sorry. Yeah,
that
you're
isn't
right, you're right.
applicable to this case.
You're right. No further questions, Your Honor, at this time.
Mr. Dean, cross-examination.
Thank you, Your Honor. In regards to your investigation in this particular matter, was it your understanding that sometime in July, Mr. Hunter had received a physical copy of the bill after it had been texted to him?
yes,
And so he was able to read the issue with the storage fees, and decided that that was notice to him to come get the truck. Because he got a $10 per day fee for if it was there 48 hours after the repair.
correct. That's why he stated he came and picked it up, is because of the storage fees.
And he didn't do that within 48 hours of receiving the bill, did he? Because he clearly didn't wait. He waited until sometime after business hours on August 6th to come in and pick up the vehicle with the second set of keys.
That is correct.
Did anything in your investigation reveal Mr. Hunter ever attempting to directly communicate or question with Mr. Strickler the charges?
No,
In fact, Mr. Hunter only told you what his position was after you made contact with him about a reported allegation of a theft for services.
that is correct.
And the $2,000 was his personal estimate as I'm reading your report, correct?
Yes, he didn't indicate to me when I spoke with him that that was a prior agreement. That's what he indicated to me he felt was a justifiable amount.
So, and you've taken the statements from the two parties. You weren't present for any of the prior conversations as to whether or not 6 injectors had been discussed or not discussed, correct?
Correct. I had no evidence one way or the other.
You've taken each party's statements that they've given you and compiled them in your report.
That's correct.
And in regards to did Mr. Hunter ever indicate to you that since he would never buy those Napa batteries, that he had replaced them and was going to return them to you with that $2,000 check?
No,
Had Mr. Hunter ever made any statement to you that there's no way in the world that that starter could have been inoperable at some point?
he did make a statement about the starter.
Was the statement that he just not authorized that work?
I do remember him telling me that he didn't authorize it. Didn't authorize the work. I believe he told me that the starter that was on it was under warranty. I don't recall him making any statement about the starter couldn't have gone bad or anything like that.
Did he advise you that along with paying for the $2,000 that he estimated that you should owe, and clearly didn't offer to return the batteries, did he indicate that he was going to proceed with a warranty claim?
No,
Did Mr. Hunter ever indicate to you that he had received phone calls from Mr. Hunter ever indicate to you that he had received phone calls from Mr. Strickler?
no, he did tell me that he received a text message with a picture of part of the document.
Did he show you the balance of the text message exchange dating back into June between Mr. Strickler and himself?
Not that I recall.
I don't have any further questions. Thank you.
Any redirect, Mr. McClendon?
No, Your Honor.
All right, thank you. Is Sergeant Cordell released then? Do we need him for anything else?
I have no need for him, Your Honor.
I have no need to truly call him. Thank you, Sergeant Cordell.
Roger
Thank you.
Cordell, you are excused from your subpoena, released at this time. Thank you.
you.
Mr. McClendon, have you other witnesses?
Your Honor, at this time, I'd call Scott Hunter.
Very well. Mr. Hunter, if you'd come back to the screen, please. This is the defendant, so if you please, I could do it one of two ways. I could keep you under your oath from a week ago, but I'll go ahead and just give you another for refreshment. At this time, sir, would you please raise your right hand? You solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
All right, thank you. Please proceed, Mr. McClendon.
So, Mr. Hunter, just to kind of go back over what we had stated previously, what did you believe the final balance should roughly have been?
$2,000 for parts of labor.
Okay.
And where did you,
I'm sorry, Mr. McClendon, he cut in and out there. Can you try that answer again?
I was of the opinion, Your Honor, that the expense should have been in the neighborhood of $2,000 for replacing the two injectors and its labor.
and where did you get this estimate that you did yourself from?
Having had vehicles worked on, and also I researched it on the computer, on Cummins forum sites, and that's pretty much a standard.
Your Honor, then I want to object to based upon foundation for his answer as to the evaluation that he's come up with, searching on forum common sites. That's clearly would indicate that he does not have foundation to be presenting that opinion.
I'm going to sustain the objection that we don't know if the information is reliable. It is hearsay, and so we don't know if he has a proper foundation to testify from or not.
What was your understanding of the work to be done?
It had a miss in it, and he was to replace the injector that was bad. And he later said that had two of them that he wanted to replace. And that was the sum total of the work, and it would need a new valve cover gasket.
You said it would or wouldn't need a new valve?
Would.
Okay.
At any time, did you talk the discussion of placing a injector pass-through harness?
No. And it wouldn't have needed one, most likely because it was less than a year old.
Had you previously replaced the injector pass-through harness?
Yes.
You're saying you replaced it within the year?
Yes.
That because they want.
Did Mr. Strickler provide you with any pricing options on his work to be done?
He told me that the injectors would run in the neighborhood of $400. And that's the only thing that he ever priced.
And was this consistent with the with your parts lookup that you had done on the internet?
Yes, it was.
And these and looking up these parts, you looked at popular resources such as O'Reilly's.
Yes.
Your Honor, I'd like to refer.
I'm sorry, can you say that again, please?
Your Honor, I'd like the record to reflect that Mr. Hunter is referring to Defendant's Exhibit A, the screenshot.
Exhibit A, which has by agreement been admitted prior to hearing today. So Defendant A is admitted, and I will take note that that is what he's referring to. Hearing no objection, you may proceed. And there was no objection when it was admitted. So go ahead, please.
Sorry, Your Honor, I had no objection to him clarifying what exhibit he was referring to. I still don't have an
Yes,
objection.
I realized after I made that comment, you had not objected to it. So counsel, Mr. McClendon, please proceed.
What was the first contact you'd had with Mr. Strickler? Do you drop the truck off?
When he called to tell me that he had gotten it in and the number one injector was hung open and it was definitely bad. And he thought we needed to replace the number 5 injector too.
What date did that happen on?
It's been in May. I don't think this has
I mean-
records going back that far.
You don't. Okay. Did you have any other contact with Mr. Stickler after, or you go down a different line? And so did you agree to replace 1 and 5?
Yes.
Did you agree to replace any other injectors?
No.
Did you agree to any other work to be done to the truck?
No. Just the injectors, and naturally it would need a new valve cover gasket when you're going back together.
And what was the next contact you had with Mr. Strickler?
He at one point said that he was having trouble getting caught up. He'd had some vehicles that was running him behind schedule, and that he wouldn't be able to get the pickup out quite as quickly as he had thought he could and would.
And what time frame was that?
I'm
Oh,
sorry,
that was
I'm
short.
not hearing you very well, Mr. McClendon.
Approximately what time frame was that conversation?
Shortly after the phone call where he told me that it was going to need a number 1 injector and probably a number 5.
And did you have any other contact with Mr. Strickler?
From time to time, I would see him at or around his place of business because he's in the back side of East Side, and I would buy fuel there every day. So would see him. It's not like I wasn't available.
Did you ever approach him?
I'm sorry, what was that?
Did you ever approach him while you were fueling at East Side?
Yes, the day that we discussed the fact that he was running behind, and I told him that was not a problem. It wasn't an issue. I was just going to get that pickup ready and advertise on Purple Wave to sell it.
Did you have any other contact with Mr. Strickler after that, besides seeing him at East Side?
No, not until we got the text, the stuff we've already discussed.
Mr. Hunter, why did you go pick up the vehicle?
Because when he sent me the hard copy of the bill where I could read it, which we would have received on or about July 21st, it said right on it that anything after 48 hours, you started paying a storage fee. And that was already going to be day 3. We went and picked the pickup up and brought it home. And I knew that we needed to discuss his discrepancy, as is already in writing in a text to him.
What day did you go pick up the vehicle?
Sorry, I can't hear the question, Mr. McClendon.
What day did you go pick up the vehicle?
Let me look at the calendar here right quick.
The question was, when did you pick up the vehicle?
Yes, Your Honor.
the afternoon of the 23rd, July 23rd.
Do I understand correctly? That was a weekend when the business was closed?
I don't know if he was closed or not, Your Honor, but it was Sunday on the 23rd.
Sunday? Thank you.
Did you have any other contact with Mr. Strickler after you picked up the vehicle?
Any other questions after he picked up the vehicle? Is that the
Any
question?
other contact, Your Honor?
So,
Yes, I had a conversation with him after that when he called me up and accused me of theft, that's not the way he does. And I told him, said, well, let's get these discrepancies worked out. And that call would have been on the 24th, Monday, the day that the pickup was picked up,
the day that it was or the day after?
the day after.
Okay.
Did you and Mr. Strickler have a conversation relating to pricing or trying to resolve those discrepancies?
He called and told me that I had stolen from him, and that was pretty much the end of the conversation. I mean, he was very mad. He's short and to the point, and didn't care to discuss it. So I figured we better just put together an estimate and hand him the money that we thought it was worth and go from there.
Did you start building that estimate?
Can you hear him, Mr. Dean?
Yes, I can.
Okay,
Sorry, I was muted. I was talking with my client just a minute.
okay, go ahead. Dean.
Well, I had a good idea ahead of time of what it should cost because I knew what injectors should cost to be put in the thing. The labor that he showed on his bill was quite fine.
And did you have any other contact after the phone call on the 24th with Mr. Strickler to try to resolve this issue?
No, after he went through sheriff's departments in two counties and Greenwood County, informed me that Mr. Strickler was accusing me of theft of services. I gave my report to them and let it go to the law enforcement.
That was your conversation with Mr. Cordell, correct?
Yes.
No further questions at this time, Your Honor.
Cross-examination, Mr. Dean?
Thank you, Art. So, Mr. Hunter, you believe we'd already gone over this last time, but you'd received a text back in June telling you the truck was done, correct? June 13th.
Yes.
July 7th, you received it, and you didn't make any contact from June 13th clear into Judge. Do we still have you? And you then received, you didn't make any contact with Mr. Strickler from June 13th through at least July 7th, correct?
No, that's not correct.
All right. What
After
did you just, hold on. What did you discuss between those dates?
I went by his shop to discuss the whole thing, pay for the truck, get it out of there, and I was told that the shop was closed for a week or 10 days. He was out of town, something, a family matter, maybe a new grandchild, and he was gone visiting.
Mr. Strickler, do you recall your testimony from last week? Oh, excuse me, Mr. Hunter, do you recall your testimony from last week?
Yes, I recall having spoken on here. Do I remember all the dates yet? It was things that I don't have in writing to a certain extent.
Would you agree with me that you never mentioned anything about Mr. Strickler being gone for a week to 10 days and that you'd attempted to make contact with him?
Actually, I do believe we did discuss that, sir.
Your Honor, I just asked the court to take notice of the record that's already before the court.
Oh, I will do that. I will review that, but it does seem to me I heard something about a grandchild being born, but I don't remember exactly where that conversation fits. So I will review the record and take judicial notice, counsel.
You know, what I would say is I don't believe the record would reflect he ever attempted to come in and make any type of payment. And that's why
Okay,
he wasn't
that I don't
do it. I think there was he maybe attempted to testify to that fashion in regards to why some of the repair time was taking so long.
Yes.
Okay, so you don't know when that occurred, but you made that attempt sometime between June 13th and July 7th. Those two texts, correct?
That is correct.
And then on July 7th, you received a text. It had a bill on it you couldn't read, so you said mail a hard copy. Correct?
That is correct.
And you're there every day buying fuel, correct?
Yes, sir.
So on July 8th, why didn't you just go in and get a hard copy and pay it?
I told him to send me a bill. I had tried to pay. I told him to send me a bill. I figured it would be forthcoming. We could take it in and sit down and mull it over. We, meaning me and my family, and we would make payment. Also expected to be for the work that I had asked to be done.
So you were already suspicious that the bill was more than what you believed it was going to be?
I was suspicious when I sent him the text saying send a hard copy because it appears we have discrepancies.
I thought you said send a hard copy because you couldn't read it.
We can't read it. It's only half the bill. The bottom half of the sheet is not there. And I
Yeah.
also put in text form that there are discrepancies. You were to send a hard copy of the bill that is readable. You did send a text, but it won't enlarge or print for me. That will need sent, so it's readable as there are discrepancies.
So what's the difference between him mailing you a bill and you just going there, since you're there every day, as you indicated, and picking it up on July 9th, 10th, 11th, 12th, 13th, any of those days, and just taking care of, you've been given a hard copy at that point in time if you just asked for it, would you not?
Was it illegal, sir, for me to ask for a bill to be sent?
I'm not, you don't get asked questions, sir. I'm asking you questions.
Okay, the answer is every other vendor we deal with sends monthly statements. Some of them send them out by email, but they're readable, they're printable, they're doable, and they're discussable. That's what I wanted. I wanted where I could read and see what we had and figure out why there was such a discrepancy and go from there and get the matter ended.
So it couldn't have just been handed to you. It had to be handed to you by the U.S. Postal Service, is what you're saying.
I suppose it could.
The report was made that the vehicle was removed on sometime on August 5th or August 6th. Now you're stating that occurred on July 23rd or 4th.
I don't know who said it was on August 5th or 6th. I removed it after I got the letter from him, and it is dated the 19th day of July in Wichita.
Are you aware that
which
Mr.
means a couple
Strickler,
days after that, it
are
would have
you aware
been.
that Mr. Strickler keeps those premises under video surveillance?
I have no idea. I would hope he would. I'm sure the gas station does too.
Now, you indicated you just had the pass-through harness replaced in the last year?
Yes.
By who?
What?
By whom?
Brandon DeBose was the mechanic on it, sir.
What was the last name?
Brendan
DeBose.
DeBoses?
How's that spelled?
DUBOSE.
D David or B boy?
Brandon DeBose with a B. And the last name is DUBOSE, ma'am.
Okay, thank you.
So what work did he do on this vehicle?
We seem to be having some electrical issues on it. And so we started replacing some things that he thought needed done.
And when was this work done?
Approximately a year before we headed in the shop up there.
Do you have that bill?
Didn't need a bill.
Who is
Along
where is this
along with
Brendan?
being an accredited mechanic for the U.S. Air Force, he's my son-in-law.
All right, where's he located?
McConnell Air Force Base.
And so I just want to make sure I'm understanding what you were trying, when you tried to contact Mr. Strickler. So we've got the initial take in the vehicle. The initial or the second contact, was that correct? You had a discussion with him when you first took him the vehicle, correct?
Yes.
You had a discussion with him where you say he only mentioned that 2 injectors probably needed to be replaced.
Actually.
As a second contact, correct, sir?
Actually, there would have been more than 2 contacts because we spoke with him today that he agreed to work on the vehicle. Then we spoke with him later when we delivered the vehicle on the day he wanted it brought in. And then we had discussion later on as we just already have put on the record.
And so your position is that Mr. Strickler never bothered to mention to you that, hey, these injectors all have the same amount of mileage on them. Probably makes sense to replace them all with 2 of them. 2 of the 6 already bad.
No, it did not.
Have you?
I would not have
what did you
signed.
do with the? What did you do with the batteries that are in that vehicle? The Napa batteries that were put in it.
They're in the pickup. They're sitting in my yard. And when I talked to Sergeant Cordell and we discussed it, I said, if he'll bring my batteries back, I'll gladly give him his Napa batteries.
So Mr.
I've never had any
Cordell was,
batteries brought back.
so Mr. Cordell was wrong on his testimony as well. He didn't accurately get all of your words copied down, correct?
I'm not going to sit here and say that man's wrong. We had a discussion. We were going through a lot of issues at once. And it's a matter of his record that it was brought up.
Did you work a warranty claim in regards to the starter?
I can't. I didn't have the starter.
Did you attempt to ever get the starter?
No, at this point, it was best for me to stay away from Mr. Strickler.
How much did you receive for the vehicle when you sold it?
I haven't sold it.
So even though that all this work was to get it sold, you haven't sold it.
No, sir, we haven't sold it. There's a certain amount of issue with what he claims is an affidavit of lien against the vehicle.
Okay, I totally did not know this existed. That's so cool. So it says on here, I, the undersigned, certify that the owner's requesting consent, work was performed, repairs made, or improvements completed, and that reasonable value for materials and services performed were charged. The vehicle has been in my possession since the date of repairs were completed to the present. Therefore, I claim a lien of said vehicle based on these charges. So he's certifying that the owner requested the work be performed. That's a little iffy.
He doesn't have possession of the vehicle. So.
No, he does not.
And in regards to the affidavit of lien, where is that? Where did you receive that from?
It was in your petition.
Yeah, it's not filed a record anywhere perfecting any type of a lien with that document, sir. Would you agree with that?
No, I wouldn't agree to it because I don't know anything about it. It says it's a mechanic's lien sale. It shows that he's put a lien against it. Of course, it also shows that he's had an auction.
So if you didn't know anything about it, then you don't know anything about it, then you didn't make your decision not to sell the vehicle based upon this paper.
What? Would you rephrase, please?
So if
I
you
wanna
don't
understand
understand
this.
or know anything about it, you didn't make a decision not to sell this vehicle based upon this paperwork.
No, he explained when he came onto my property that he had a lien against it. And he contacted, I'm assuming, my bank to find out if it was mortgaged in any way, shape, or form.
I'm sorry, sir.
And it,
Excuse me, sir. Are you, when you say he checked or he had a lien against it, do you mean Deputy Cordell or do you
no,
mean
Mr. Strickler.
Mr. Strickler? Okay.
Yes, I'm sorry.
Mr. Hunter, you had, before you ever received a copy of this petition, because you indicated it hadn't been served, you've had possession, according to you, of this vehicle since July 24th of 23, correct?
Yes.
And you
Well, actually, I think
didn't
it would have been
receive any type of-
23rd, but
whichever day, and you haven't, and even despite not, then you would have had it all the way through dang near December before apparently service was actually effectuated on you and your attorney entered his appearance in this case, correct? December of 23.
yes.
So even though you knew based upon the text that you had disputes with the bill, you didn't ever attempt to go in and deal with that with Mr. Strickler. You just went in and got the vehicle after hours, correct?
It wasn't after hours. Did I call that after hours or mid-afternoon?
Your Honor, I don't have any further questions for this witness. Thank you very much.
Anything else, Mr. McClendon?
The defense would rest.
All right.
Your Honor, I have a brief rebuttal.
Go ahead, Mr. Dean.
Your Honor, I recall a client stand.
All right. Since I re-administered an oath for him, I'll do it for you. Sir, do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, ma'am.
Thank you. Of course, you are still under oath. That's why I said I really didn't need to proceed with the oath. But Mr. Dean, you may proceed.
All right, thank you, Your Honor. Mr. Strickland, just to clarify a couple of issues. When you made the repairs on the vehicle, what did you find in regards to that pass-through harness? Did you find fairly recently installed
No, they
piece
were
of
not.
equipment?
No, they were not. They looked to be OEM injectors that had been subjected to heat for years. They were not new.
And in regards to the pass-through harness,
Yes, they were not new.
and they look, again, the pass-through harness,
They OEM harnesses. They were not new. They looked to be factory originals.
and just for the court's information, which I'm sure she's aware of this, when you say OEM, is that what you mean by the factory original?
Yes, factory original.
In regards to the time period in which Mr. Hunter is now saying that you were closed down for a week to 10 days, what do you have any knowledge of what he's referencing?
No, I do not. The only time my shop has been closed was July of 21. I was closed for a week. Other than that, I may have been gone a couple days, but my shop has always been open. I have 2 employees. My shop is open 5 days a week, from 8 to 12 and 1 to 5.
Was there any time in late June or early July of 23 that you were gone any amount of time for a birth of a grandchild or anything of that nature?
I did have on June 22nd, my granddaughter was born, but we didn't go over until the weekend. It was the following weekend is when we went, which would have been the 25th is when we went to see her for the first time. And that was a Sunday.
So that's not a day you'd regularly be open.
No, we're not open Saturdays or Sundays.
So while there's some truth in the fact that you acknowledge that yes, you did have a grandchild born last summer, you didn't close your shop down for that.
No, I did not.
And you were never closed at any point in time for a week to 10 days.
No.
Did Mr. Hunter ever call you or attempt to walk in, since he said he was there on a daily basis, and have a discussion with you about anything he was disputing on the bill?
No, he did not.
And in regards to the time frame in which you reported this to law enforcement about the vehicle being removed, how is it that you knew the date and time?
So I came in on Monday the 7th, which would have been August 7th, 2023. And I noticed that something was missing. I do all the scheduling. I do all the diagnosis. I do everything as far as pickup and release of vehicles. And I noticed that something was missing. So I went in and asked my head mechanic if Mr. Hunter had stopped in to pay his bill, and he had not. At that time, I went in and tried to call Mr. Hunter, and I left a message. I did not talk to Mr. Hunter. I left a message saying that that is not the way I do business. If you're going to pick something up, arrangements need to be made as far as payment goes. And that, I think I said something about it being 60 days, sitting there for 60 days and no contact. That was on the 7th.
And did you have a way to confirm and be able to actually visualize when he arrived to pick up the vehicle?
Yes. The gas station, I work out of the back of Eastside Service Station, the gas station that has surveillance, and they showed Mr. Hunter showing up in his maroon Dodge and Mr. Hunter getting out and getting into his other Dodge and leaving in his Dodge on Saturday, August 5th of 2023.
And that's what you reported to law enforcement?
And that's what I reported to law enforcement, and I reported it on that Monday.
And that was August 7th?
Yes.
Your Honor, I don't have any additional questions. Those are the only limited issues I wanted to.
Examination of this rebuttal evidence only.
Mr. Strickler, you said that you were never closed, but was there a period in that between in June or early July that you were not there, but the shop was open?
Yes.
Okay. And how long was that period?
I run a towing service and several other things that I have going on. So I'm in and out as I'm mechanicing. So there's several times that I'm not there through the day. I have 2 employees that run my day to day.
But your employees do say if somebody comes in and wants to talk to Mr. Strickler, they say he's not here.
I would assume, I don't know what they say because I'm not there.
No further questions, Your Honor.
Anything further of this witness, Mr.?
Just to clarify, Mr. Strickler, would there have been any reason why your employees would have said, well, he's going to be closed he's not going to be available for the next 7 to 10 days due to the birth of a grandchild or some other family event?
No.
I don't have anything further.
Anything further, Mr. McClendon?
Oh, Your Honor.
All right. Any other evidence from any party?
We are.
No, Your Honor.
Parties having rested, do the parties want to give any closing? It would need to be brief if so.
Just briefly, Your Honor,
Yep.
which is always a little bit of a question on how brief I could say, according to some judges. Your Honor, essentially what I've just argued to the court is we have an issue where obviously we have credibility issue that has to be determined by the court. That seems to be the primary issue here. I would just argue that Mr. Hunter's testimony and some of his dates and times appear to be more convenient than grounded in any other way to verify, whether it be through a log that he ever kept or just the nature and tenor and demeanor of his testimony. I kind of find it hard to believe that if a mechanic said, listen, you're in here for these 2 injectors and never mentioned repairing the other 4 since they would all have the same time and wear, that wouldn't seem to be just a normal course. Again, I think the credibility and the way that the parties have acted in this particular matter is important for the court to determine. In regards to the repairs that even my client acknowledged weren't authorized, they were also required to perform the repairs that were. In regards to the efforts to get the vehicle to be able to move. If the batteries aren't serviceable, they're not serviceable. If the starter isn't working right, the starter is not working. So I think those are necessary repairs, and I think under Kansas law would come in. Even Mr. Hunter indicated that he didn't exactly know what it was going to be. He says he only agreed to fix 2, but then basically just says it was kind of, get it running. Is essentially his testimony as I recall it. And I do believe again that Mr. Hunter has kind of changed his testimony slightly from last week to this week. That being said, Your Honor, it would also appear to be consistent with somebody who was owed a bill that they've made multiple efforts to contact, as opposed to somebody who, no, I never heard from anybody. But even though he's there on a daily basis, never went in weeks to try to rectify the issue on any dispute that he believed he had. Instead, showed up after hours to remove a vehicle. And again, the report, which was made on August 7th, indicates that Mr. Strickler clearly told him that it had been removed on that weekend. I think that's consistent with basically Mr. Strickler's veracity on this particular matter, and also undercuts Mr. Hunter on this particular matter. Because now he's back and clear up to July 23rd that he picked up the vehicle. I could go on and on, Your Honor, but I believe that basically the repairs have been authorized, and some additional issues that came up, and the equitable theory of quantum merit would require my client to be paid for the work that he did. And again, here we have this vehicle that was supposedly the work being done to fit, so it can be sold. It hasn't even been sold, and we're a year later.
Mr. McClendon, any brief closing?
Your Honor, I would I would just ask the court to recognize that first off, begin with, there are some issues as to the credibility of whether or not all these parts that are being used are OEM parts. They were, some of them, as pointed out earlier, were ordered off unknown or irrecognizable websites, and that uh, the quality and legitimacy of these parts are not known. I'd also ask to remember that not all work was agreed upon. He went in and replaced his starter and batteries without ever contacting his client to run up an extra $1,000 on his bill when it was stated that his client wanted to keep costs low. And that is all I have at this time, Your Honor.
Gentlemen, thank you for your presentations and arguments. When Mr. Scott Hunter testified on day one of the hearing as the first witness called by the plaintiff, he did tell us that he was somewhat trained as a mechanic himself. It wasn't his profession, but he'd done a lot of it. And at this time, he just didn't want to go to the trouble of doing it himself. He didn't have the time. He was working 7 days a week during the drought with his digging service. So thinking that it was missing on at least one cylinder, he did take it to the plaintiff. They did have a discussion. There's agreement between the two of them that they did discuss missing cylinders and that it was going to be sold. There was kind of a split between the parties as whether the mileage should be considered high or not. Sounds like it had a good number of miles, but the defendant said it was high, and plaintiff said he's worked on trucks that have, I think he said up to 500,000 for that kind of truck and engine. But in any event, the defendant said he said to keep the cost down because he was just going to sell it. And, keeping the cost down, that sounds like something reasonably a person would say, but that doesn't mean that the plaintiff didn't keep the cost down. He very well could have kept the cost down, and the prices are what they are, especially in this day and age of 2024 when, or even 2023, when everything just keeps getting more and more expensive. The defendant testifies that they had a second conversation, or the plaintiff testified that they had a second conversation, which the defendant denies. Or maybe he admitted that one. I take that back. He admitted that they did have a second conversation about numbers 1 and 5 of the lifters needing replaced. He denies the further testimony that the further testimony of the plaintiff that they discussed, hey, they've got the same amount of miles on all 6 of them. If 2 are out now, 1 may be out next week, and then you'll have to replace that, and it could be more expensive. And so they went ahead, according to the plaintiff, and agreed to go ahead and fix all 6. And that did require the list of parts for the most part on Plaintiff's Exhibit 1. There was discrepancy over whether it needed an injector pass-through harness, whether that was old or not. Defendant said it was new. Plaintiff said it was from the factory, needed replaced. Now, I believe even the defendant agreed that 2 of those gaskets would need to be fixed. And the arguments or statements the plaintiff made, I think, make sense, that they would have had that conversation. We just, well, go ahead and replace the 6, because if you're going to try to sell it and the customer takes it out and tries to drive it, and here comes another bad lifter, that's going to be an issue. But as I go through these items on the bill, the ones that the defendant says he didn't authorize or ask for includes the changing of the starter replacement, and the batteries. And I do think that that should have been discussed, the batteries and changing the starter. And plaintiff suggests that it was, defendant says it wasn't. Or plaintiff's argument was that he couldn't get it into the garage to fix it, and if the defendant wanted the truck to be fixed, it'd have to have the starter replaced, the batteries replaced, and get it into the shed to be fixed. He certainly couldn't, defendant, sell that without a starter and batteries in it. But I would have said, just give the batteries back if the defendant dislikes those batteries that Napa sells, and get his own. But that didn't happen. As I heard just moments ago, the batteries are still sitting in the truck in the defendant's yard. And same with the starter. At this time, I find that the section of the bill showing the expenses and the prices charged, as well as the labor being $1,675.20, as well as the labor $5,497.87, sales tax, or shop supplies, let's see, shop supplies 20, sales tax 683.34, for a total of $7,876.41 is due to the plaintiff and owing by the defendant, and I grant judgment in that amount to the defendant. Now, Mr. Dean, as I understand it, that figure does not include storage fees, is that correct?
That should include. That did include the storage fee.
Where did you see that on the bill? I mean, okay,
So-
50 days. I'd strike from that the 50 days storage of $500 and the 30-day 10% late fee of $720.
So Your Honor, if you would go to what's been marked as plaintiff's exhibit. Sorry. It's gonna be plaintiff's exhibit number 1, and the bill's dated August 10th, 2003. It actually, for whatever reason, the billing software populates that it adds it into the labor. But at the bottom, right above that line and the totals, it has 50 days storage, 500, 30 days, 10% late fee, $700.20. When I proffered to report that when I've done the math on this bill, those numbers get added in and show in the labor line at $675.20. And if you add those numbers to the 500 plus the 720, plus the labor and some of the other charges up above, that gets you to the $1,675.20.
Well, I'm also looking at plaintiff's exhibit 12. That does not have the late fee added to it, does it? Is that without those two figures?
12 is the bill that was first initially sent to the defendant,
Right.
and there had not been any of those assessments made.
So if I take away from that 7,800, if I take away the storage and the late fees, does that not revert back to the original bill that was emailed of $6,562.20? Haven't done the math on it, so I don't know.
I believe that it should. 6,572.20 is up.
That's not quite what the bill shows, $6,562.20. But I thought there was some testimony to that effect, that without labor.
That sounds correct, Charles. Yeah, 6,562.20.
Okay. Now, the reason I'm not going to authorize the storage and the labor is because I don't believe that there was testimony that the parties agreed to this. Nothing was in writing, so the defendant wouldn't have seen those figures or that agreement, and he didn't sign it. And even the exhibit, defense exhibit 2 or exhibit B shows that it wasn't until February 16th of 23. Well, that would have been before he brought the vehicle in, but he did put it on his Facebook feed that he was going to start adding storage and late fees. But I don't see where I didn't see any evidence that that was discussed and agreed to before the bill went out. So I'm going to strike that amount, $500 for 50 days of storage and $720 for 30-day late fee. I'm striking them because I think that that is what the evidence supports, but I can understand the plaintiff's frustration in having the vehicle so long without payment. And I think that it's very troubling that the defendant would just go in on a day off and take the vehicle with an extra set of keys. I might come to a different opinion on whether it was only civil versus criminal, because he did drive off, the defendant did drive off with batteries that didn't belong to him. If he didn't have an agreement for them, he would have trespassed if the building was closed. I mean, there are a lot of possibilities, but I don't make any decisions on those possibilities because they're not asked for and they're not really relevant on this particular case. Is there anything else I need to address, counsel?
Just to clarify, Judge, judgment is granted in the amount of $6,562.20.
Yes.
I believe is what the court stated just a minute ago.
Yes, that is what the court
And
stated.
then I know we had made a request for prejudgment interest. That's in any event, however the court's going to rule on that.
That is, Mr. McClendon, do you want to be heard on prejudgment?
Your Honor, if the court decides to award prejudgment interest, I'd ask that they stick to the statute award statute limited amount, which I believe is 12%. Is it?
Yeah, that would.
It's 12, yes.
Yeah, it can't be what it's got to be that.
And I presume counsel's referencing this added paragraph that I'm not considering where it does talk about late fees or whatnot. So,
Well, because this is what I would refer to as a fairly liquidated amount. I believe under the statute you have authority to grant prejudgment interest because we've been sitting here. Not only it's not Mr. Trickler's been out almost 10 months in regards to the labor and the materials that he supplied in on this item. But I would say that essentially, I think it'd be, that it wouldn't necessarily, I don't know when the court would want to start that, whether it was going all the way back to the state bill or to the filing of the petition, but I would suggest the filing of the petition.
Your Honor, if I may, I'd also like to bring to the court's attention that we did and not to fault Mr. Dean, but we did wait a large amount of time for him to wrap up trials and such as well.
I will grant prejudgment interest. I will follow the suggestion of the date of the filing. I'm looking at the date of 7/7/23 when the first bill went out through email, but I will grant prejudgment starting with the day of the petition and of course post-judgment from this date. Anything else? Mr. Dean, I trust you'll file the journal entry.
I will get it prepared as fast as I can. I will tell everybody that my assistant's out the rest of the week, so I'm somewhat flying, I'd say with almost no arms. She's gone.
Yeah.
I'm not even gonna reference it being one-handed.
I understand.
No-handed.
And then, of course, Mr. Hunter, I'm sure your attorney will, if he hasn't talked to you about having a 14-day appeal period to appeal to the clerk of the, I'm sorry, to the Court of Appeals, the Kansas Court of Appeals. And if you do file, I believe
30
it's
for this case,
statutory.
is it not, Judge?
I don't recall what the statute says. We'll follow the language of the statute about appeals bond. There is an amount.
I think on this personal property, basically would be the amount of the judgment, would be the appeal bond.
That is what I typically like to do, but I thought maybe they had a,
And Judge, with this being a civil case, I think it's actually 30 days from the date of the filing of the journal entry.
okay, then if
The
it's
30-day
follow
appeal.
the
bond.
statute, 30 days, okay. All right, so is there anything else we need to address, Mr. McClendon?
This time for me, Your Honor.
All right, thank you. Mr. Dean, anything further?
Nothing further, Your Honor.
All right, thank you all very much. This hearing is adjourned.
Have a great day, everybody.
I find it really interesting that Judge Webster notes that she would have considered criminal charges if they were brought before her in this. She doesn't like that he went and just got the truck because he wanted to. That's not how we do things. That's not how this works. That's not how any of this works. Have a good day, everyone. I will see you soon.